MBA prayer. Almighty God, our Creator, we pray you to be with us in all our deliberations and to direct our endeavors, so that we shall continue to all humility to clarify thy name, and to that which is right and just to our profession, its members, our fellow men, and our countrymen. Amen.
Thank you very much. Please, can we give our round of applause? Please, can we give her a round of applause? We are talking about my alternate chair. She deserves better. Alternate chair, thank you very much. Gentlemen, distinguished colleagues, we will go straight into the business of the day. Gentlemen of the bar, distinguished guests, we are going to commence today's proceeding at once by calling to the high table our chairman, the chairman of this session, and he is no other person than Honorable Justice Ifeoma. You're welcome, my lord. Please, while they are ushering my lord up to the high table, please can we continue to give him a round of applause? Yes. And having ushered in my lord, may I also have your leave to bring to the high table our lead discussants for today. Our discussant for today is no other person than Dr. Kubi Udofia, my very good friend, in Babalaki and Co. in Lagos. This usher me. Our lead speaker is an expert in solvency law and company winding up proceedings, and he is also a senior lawyer. And as we mentioned before, he is a partner in Babalaki and Co. You are welcome, sir. You are welcome, sir. Good to have you around. We are supposed to have some discussions, but for now, I will hand over the microphone to the chairman of the session to direct the session as he deems fit, while we all sit down and enjoy the session. Thank you very much, and God bless you all. Please, can you clap for me as well? Please clap for me. If you don't clap for me, I will hand over the mic. Order from my lord to invite to the high table and to be part of the discussion Nsima Esquire. Nsima Esquire, please can you come up to the high table? And also to assist in that panel, I will also invite, my lord has asked me to use my discretion, so I will exercise it judicially and judiciously. I will also invite Mrs. Moji Tijani to come up to the high table. My lord, I think I think Joshua can hand over the mic to.
Not head protocol, the lead speaker, and de facto discussants are just conscripted by order of court. Sorry about that. You're welcome. And members of the NBA, ladies and gentlemen, I am honored to be called upon to chair the NBA Eket branch session on insolvency law in practice in our 2025 AWIC. We focus on the mechanics of company voluntary arrangements under the Companies and Allied Matters Act 2020 in this bar week, continuing legal education, is timely and a commendable record-breaking step for which I give kudos to Eket's bar. If you are not listening to intonation, if you are appreciating the tenor of what I'm saying, then appreciate that by a clap, because it's a virgin area for Eket bar to pick it up and bring it to fore for this discussion. Eket is the commercial nerve center of Akwa Ibom State, I think so, and is home to various companies on primary, secondary, and tertiary levels of business operations. It is therefore of urgent importance that members of the bar, both within and outside the state, get themselves acquainted with the new regime of insolvency law and practice in Nigeria. The Companies and Allied Matters Act 2020 introduced many significant reforms to the insolvency law. One of such reforms is the company voluntary arrangement under Chapter 17, particularly sections 434 to 442 of the Act. Most times, due to temporary financial setbacks, some otherwise viable companies become insolvent and fold up with attendant economic problems to society. The company voluntary arrangement under the Companies and Allied Matters Act 2020 now provides a bailout. This it does by ensuring that the value of viable businesses facing such challenge is preserved through a procedure that allows a financially distressed company to reach a binding agreement with its creditors to restructure its debt and avoid liquidation. This procedure represents a significant advancement in Nigeria's insolvency regime, offering a flexible and potentially effective mechanism for restructuring of viable companies that would have otherwise easily drifted into insolvency and liquidation. As legal practitioners, you have a duty to understand the intricacies of this new regime. You must not be found wanting. You must not be quiet when this new regime is being discussed by lawyers who rise to the challenge of the new times. Eket bar has done well to bring this up for a discussion, and I believe that this session provides all of us ample opportunity to learn and get acquainted with a new regime that was introduced by CAMA under the reform of 2020. This will enable you to advise your corporate clients on the best course of action to take when faced with financial distress. It is no longer time to rush to court to stop winding up application for winding up of companies in federal high courts. You must know what the situation is. So this session is very educative, please. And a lot of people, I told the chairman this morning when I arrived and I met an empty hall, that people think that insolvency as it is means maybe impecuniosity. And so they don't like anything that has to do with insolvency and impecuniosity. No, as a lawyer, you must like everything because you will be invited by clients who will face these situations to bail them out. Your understanding of this new regime will enable you to contribute to corporate rescue and promote economic growth and stability as part of your mandates in taking justice and good governance beyond mere rhetoric. So situate the theme of your week's, the bar week, the theme of the week, situated within the context of insolvency law and what chapter 17, the new chapter 17 of Karma 2020 has now introduced. That is why the importance of this session in this bar week cannot be overemphasized. We are blessed with the choice of Dr. Ubi Udofia as lead speaker. I understand he is an expert on this subject. The gentleman appears before me regularly in courts, and as I know him, I believe that he will do justice to this topic today. However, I look forward to an insightful and practical engagement at the end of his presentation. Don't stay aloof, don't sit on the fence, even if you have no contribution as such. Follow the discussion because it is very, very relevant to your practice. Thank you and God bless you.
With profound respect to your Lordship, the Chairman of the branch, distinguished guests, good morning everyone. So in the next few minutes, I'm going to be taking you through the mechanics of a CVA, Company Voluntary Arrangement. So going forward to save time, when I say CVA, I'm referring to Company Voluntary Arrangement. I'm going to try to be very practical as possible, and leave the theory aside so you know how a CVA is meant to work. I thought that there would be presentation slides, but I've shared my slides on your platforms, so you should be able to follow. That way, you're not lost. So you can make reference to your phone, and I'll make reference to the pages that I'm at this point in time, because that would ensure it doesn't sound so abstract or technical. All right, so we're good to go. So, for the sake of orderliness, I think I'll go through the presentation, and then at the end of my presentation, we'll open the floor for questions subject to the permission of my Lord. So in page 2, you see the outline there. I'm going to do an introduction. I'll take you through the key features of a CVA, typical CVA, and then I'll talk to you about nominees and supervisors. And this is very important because this is the money-making part. This is the part that you would have a role to play as a legal practitioner in CVAs. And then, of course, comparison between CVAs and schemes of arrangement, which we've had on ground already. And then the other one, which is the other rescue procedure introduced by KAMA. By the way, when I refer to KAMA, I hope we understand it's Companies and Allied Matters Act 2020. Not the other KAMA, KRMA. So, and then I'll look at the CVA process. I'll also look at the grounds for challenging CVAs, which is also going to be of very, significant importance to us lawyers. And then the remedies for aggrieved parties in the CVA process. And what happens when there is a default in implementation of proposals in the CVA. And then we'll look at the advantages and, of course, the shortcomings of a CVA. And then if time will permit, I'll just take you through the key features of the first CVA we had in Nigeria, which was in relation to a company called Tourist Company of Nigeria. They're the owners of FIDA Palace Hotel in Lagos and the Keja Hotels PLC. All right, so by way of introduction, we are now at page 3. You're looking at your phones. Before KAMA 2020, what we had on ground in terms of insolvency processes and insolvency practice was majorly like the distinguished MC or CPC chair explained or stated before, we had winding up. So when a company was not doing well or had failed to pay its debt as they fall due, we rushed to court to file for winding up or liquidation of the company. We also had receiverships. If you were a secured creditor and you had your security document, which empowered you to appoint a receiver if there's a default. You could also appoint a receiver either out of court or you go to court to appoint your receiver. Of course, people preferred out of court appointments to maintain that element of surprise so that you'd march to the company with policemen to seal up the place after getting your orders of court ex parte. So that's how insolvency practice was. And of course, I'm not saying that these have been consigned to the rubbish bin of history. Banks still go for this, for reasons best known to them and for obvious reasons anyway. So, but formal insolvency proceedings were limited to winding up, that's liquidation, and receivership. We did not have any formal rescue or restructuring processes in the law. Companies Act 1968, Companies and Allied Matters Act 1990. Of course, people could restructure informally. They call it out-of-court restructuring or, workout arrangements. So sometime in the 80s, there were some certain developments in the UK. It's very important, to highlight this so that you know where we're coming from, that we didn't just originate the CVAs. And it's important too, because it's still novel. We don't have so many authorities. So if you have these cases in court, you know that you can rely on English authorities, because our CVAs are modeled after what we have in the UK. So sometime in the 80s, specifically in 1982 in England, they were looking for alternatives to liquidation and receiverships, and we're looking for procedures that would be simple and out of court, so that it's not in every case that you have to approach the court to settle disputes relating to insolvency or failure to pay debt. Like my Lord mentioned, sometimes a company may be unable to pay its debt due to temporary cash flow problems. So the business may still be viable. But the problem we had then with liquidation was that everything is like killing every ant with a sledgehammer. So even viable businesses were destroyed. So the court committee came up with certain recommendations. We're looking for, how to restructure outside formal proceedings and how to also restructure in such a way that you have the debtor maintaining the company, what we call debtor in possession. So you don't bring in a liquidator, an external person, or a receiver. So you leave the managers of the company, directors, to keep running the company, because maybe what has befallen the company is not necessarily the fault of the managers. For instance, let me give you a classic example so it won't look like something, very theoretical. The COVID period, we had many companies facing difficulties because of the lockdown and other government restrictions. So if you're selling things on the street and there were orders for lockdown, of course you have cash flow problems because you won't be able to go out there to sell. But it didn't mean that those businesses were not viable. It only meant that they couldn't sell and make money, and most of them ran into debt. They couldn't pay their debt as they fall due, cash flow challenges. So the court committee, they were looking for how to deal with these sort of challenges companies face without having to put them in liquidation and destroying them and destroying value. So they came up with the CVA in the UK Insolvency Act 1986. I think that's enough background. So that was the first time the CVA was introduced, the 1986 Act in the UK. So fast forward to CAMA 2020. 30 years after we had CAMA 1990. So what we now did was, we also considered introducing formal restructuring or rescue procedures in our law. And so, of course, we adopted, because CAMA, Companies Act 1968, CAMA 1990 were all modeled after UK laws. I think CAMA 1990 was modeled after the UK Companies Act of 1948. So it was quite easy to adopt the CVA and the other rescue or restructuring procedure that was adopted in CAMA 2020 is the administration. But our focus today is the CVA. So right now, of course, CAMA makes extensive provisions like my Lord highlighted for CVAs in chapter 17. And you also have the Insolvency Regulations 2022. I happen to be in the 7-man committee that drafted that regulation. It also makes extensive provisions for CVAs. And then, instructively too, you also have the Business Facilitation Act that was passed in 2023. It also touches on some part of company law and insolvency proceedings and even the CVA. So we'll move to the next page. So the key features of the CVA, if you look towards the right, you see I've listed a lot of companies. Some of us may be familiar with these companies undergone CVA, especially in the UK. There are so many of them there. Towards the left, their logos. But let's look at the key features of the CVA. First, what is a CVA? We've been talking without even introducing what this CVA is. It is simply a statutory agreement. Please note this, between unsecured creditors. Has nothing to do with secured creditors. So it's a statutory agreement, a binding agreement, a formal agreement between unsecured creditors and a company that is facing financial difficulties or at the verge of insolvency. And this agreement is to ensure that the company does not become insolvent and the company is able to pay its debts and the company is able to compromise its debts with the creditors. So in simple terms, formal agreement, statutory agreement between unsecured creditors and the company. And this agreement is to ensure that they look for ways that the company will be able to pay its debt and won't go into insolvency. So it's informal. When I say it's informal, that means it is not meant to involve courts. It's meant to be as simple and as informal as possible. That's meant to be a strong point for CVAs. And it only becomes formal. Well, courts are only meant to be actively engaged where they are challenged. We look at how CVAs can be challenged subsequently. So CVAs, company voluntary arrangements, they can be proposed by directors when the company is running into problems and they see that the best way to go about resolving the financial challenges is to engage unsecured creditors. So the directors can propose that. If the company is in liquidation, a liquidator can propose that. If the liquidator sees that, look, it's a good way to exit liquidation and restore the company to profitability. It can also be proposed by administrators if the company is in administration. Remember, I mentioned that administration is the other formal rescue or restructuring process introduced by CAMA. It is very flexible, so you can do so many things in a CVA. You can decide to reschedule the debt. You can decide to postpone the debt. Creditors can decide to take a haircut. You can do so many things you want to do. You can decide to even forego your debt. You can decide to swap your debt for shares or equity in the company. This is another strong point with CVA. So all what is needed is for the company to sit down with the unsecured creditors and discuss the way forward. So instead of an unsecured creditor rushing to court to file for the winding up of a company and the company losing value, so they can decide to explore ways of getting the company out of the debt trap. Of course, it requires approval of creditors and members. So both creditors and members must approve whatever proposals are made in the CVA. Another unique feature of the CVA is that it is debtor in possession. It's a term in insolvency you find a lot. When you say debtor in possession, some of you may be wondering, why leave the debtor in possession? So the manager or the directors are not removed. They are left to manage the company. So unlike the winding up and liquidation you do where you bring in a liquidator to manage the company or a receivership, where you bring in an external person to manage the company, in a CVA, the directors are left to run the company. Of course, it may have its shortcomings, but it also has the advantage of ensuring that the operations and trading and business, day-to-day business, is not disrupted. No negative publicity that directors or management has been kicked out or replaced by an external person appointed by creditors. So it's driven by nominees and Supervisors, we'll explain this later. I recall when I mentioned this initially, I said it's important because we legal practitioners are going to be the nominees and supervisors making money out of CVAs. But it's not being a lawyer, a legal practitioner, does not automatically qualify you as a nominee or supervisor, and I'll get to that shortly. So what are the roles of court? Role of court is very limited, like I mentioned before, unless it is challenged. Someone feels cheated or unfairly treated, that's when, of course, this claim are very litigious. So you expect so many, challenges of CVAs. But in the absence of any challenge, it is meant to be very informal. Courts are meant to have very limited rules to ensure it moves smoothly. So nominees and supervisors, and this is very important because this is where we make money from. So qualification before you can serve as a nominee or supervisor, you must be an insolvency practitioner. And let me distinguish between a nominee and a supervisor. So when the CVA process commences, if you have been nominated or appointed to put together the proposal, you're going to be acting as a nominee. And when it is subsequently approved by the members and creditors, which would see the process of approval, you become, and in the course of implementing it, you become a supervisor. So most times the nominee transitions into a supervisor. So it's a matter of the stage. At the beginning, you're a nominee. Subsequently, if you've done well, they can maintain you as a supervisor. So there are qualifications here for you to be a nominee. Section 705 of CAMA says that you need to have a degree in law, accountancy, or any relevant discipline. That's no problem to all of us. It's not a hurdle. Minimum of 5 years post-qualification experience in insolvency. You have to be a certified member of the Business Recovery and Insolvency Practitioners Association of Nigeria, or a professional body recognized by CAC. I'll show you the other professional bodies later, and NBA is also among the professional bodies. This provision led to some sort of controversy because people question why this association should be inserted here. But that has been taken care of because it's not exclusive to BRIPAN. Even MBA can accredit subject to the approval of CAC. So of course, authorization by CAC after being certified by the association 20 was enacted. I think it maintained the old definition of one who could be a receiver or liquidator. And this is the definition. You can check the slides that have been shared. The definition in section 868 sub 1 of CAMA 2020. If you check your CAMA 2020, you still see this definition. Which a nominee or supervisor is that he is a legal practitioner within the meaning of Legal Practitioners Act, or a member of the Institute of Chartered Accountants of Nigeria, or such other professional bodies or accountants as is established by the Act of the National Assembly. So with this, there was that argument that once you're a lawyer or a chartered accountant, you're an insolvency practitioner, you can act as a nominee or supervisor. But that conflicted with other provisions. For instance, if you go to the next page, you see, of course, it took priority over the provisions of the insolvency regulation because it's a mere regulation made pursuant to the Act. The regulation said a person duly accredited by the Commission to undertake insolvency proceedings. So that 868 ensured that there was no barrier. You just had to be a lawyer or a chartered accountant. But that has been changed now by paragraph 21, part 1 of the Business Facilitation Act. It actually deletes that definition, meaning that being a legal practitioner does not qualify you to be a nominee or supervisor. And this is also important because to be a receiver or liquidator, you need to be an insolvency practitioner and you need to be qualified as defined by the regulations and the Act. So it's not business as usual anymore that anybody could do these things. The problem with doing it without being accredited is when you go to CAC to make your filings, when need be, they won't recognize your document. Or someone can challenge you and set aside everything you've done because you are not qualified under the Act. I've set out requirements for accreditation. I won't go through that. It's in the slides, so you can look at that. And then the relevant professional bodies, apart from BRIPAN, so that there won't be any controversy that it's only one body that has been given that monopoly. You have the MBA, you have ICANN, ANAN, and even ICSAN, Institute of Chartered Secretaries of Nigeria. Of course, there are also disqualifications. I don't think any of this is relevant to any of us. Nobody's an infant or sound mind, a body corporate bankrupt, a director or auditor of that company. Of course, you know obviously there'll be conflict of interest, connected persons, and then convicts. So, I've also set out in a tabular form here the distinction between the CVA and schemes of arrangement. Schemes of arrangement have always been here, but in order not to confuse both, I'm not going to go through this. The table is self-explanatory, they are very clear. I think there are about 7 distinctions between the two that I've set out here. And the next page, the distinction or comparison between CVA and administration. Like I mentioned, today is for CVA, not for administration, but it's important for you to know the distinction between both of them. The significant distinction is that the CVA, like I mentioned before, is an agreement between all secured creditors and the company. The administration is a different kettle of fish entirely. It has to do with a formal process that allows the company to restructure its affairs and comes with what's called a moratorium, which stops even secured creditors from enforcing their rights, stops you from going to court. It's very invasive and extensive. And unlike in CVAs, in administration, the administrator takes over, an external person comes in and takes over, so the directors and management are displaced. But like I mentioned, CVA is debtor in possession, management remain in office. There are other distinctions I've set out there, which are very useful to distinguish between a CVA and an administration. Okay, so now we are at the mechanics. We are looking at the mechanics of a CVA, the process of a CVA. So I've stated here that there are 3 pages. I'm on that page where you have that document numbered 1, 2, 3 with that diagram. So, for purpose of clarity, let me emphasize that these stages are not in the law. These are just concepts I've developed for the purpose of clarity. And if you look at the mechanics, you realize that essentially there are 3 stages of a CVA. You have the stage of consultation and assessment of the proposal. The second stage would be the stage of having the meetings and approvals, meetings of creditors and members, and getting your approvals. And then after that, you go into the stage of implementing what has been approved by the creditors and the members. So this is my concept, but I believe it's very important. This essentially describes the mechanics of a CVA. First, you have consultation and assessment as the nominee or supervisor. Then you go into the meetings, convene meetings of members, convene meetings of creditors to approve your proposals, and then subsequently you implement your proposals. The proposal essentially would be how you want to ensure that the company is directed or redirected out of its debt crisis and restored to profitability. And of course, it has to be approved by creditors and members. So let's look at these 3 stages briefly. So like I mentioned before, the first stage is the stage of consultation and assessment. So normally, most times the directors, and this is one of the concern people had, the directors most times would be the ones that would have to bring in a nominee, bring in a legal practitioner, a nominee, to look at the affairs of a company and advise them on what to do. But people argue here that, here people hide things a lot because of stigma related to not paying debt or insolvency. So they may wait till the company completely crashes and it's too late until they call in the ambulance and the nominees. So typically the directors would consult with nominee on the proposed CVA, company's voluntary arrangements. And thereafter, after consulting with the nominee and making a choice as to the nominee that will drive the process, the directors, it's advisable. So these are the mechanics. They're not illegal, they are practical, based on the CVAs we've had in Nigeria and the UK. There are practical steps that will be taken. So the directors after that would have to consult the key stakeholders And it's important because if you do not consult the creditors and the members ahead of having the meetings, if you convene the meetings, they could come to the meetings and torpedo everything. They will oppose everything. And at the end of the day, the company will be worse off. So even before the meetings are convened, after the directors, they have made a decision as to the nominee, they would have to contact the key creditors and members. The creditors could be banks, and other members. They may even have to consult secured creditors to ensure that they do not disrupt the process. Very important. So it's not just a matter of convening the meetings and taking them by surprise. So that what this does is by the time you as a nominee and then in collaboration with the directors or management of the company call for the meetings, you're all on the same page with the shareholders and everything would move smoothly. They already know what you're calling them for. They know the proposals you want to table before them. You've already negotiated what to give them and what the kind of haircuts they will take. So everything is smooth at the meetings. So of course the directors will provide the nominees, the legal practitioners with necessary information regarding the company, in terms of the proposal and the statement of the company's affairs. Because the directors and the management, they are the insiders and they know what's wrong with the company. And so it's important for them to lay everything bare before the legal practitioner, the nominee. So the nominee would be able to know what to diagnose. The nominee then submits a proposal and report to court. And you'll be wondering, but I stated earlier on that the courts are hardly involved. It's merely informal. So here the court is not meant to really do anything. It's just for the records. So the court, in fact, English authorities suggest that at this point the court is almost like playing the role of a registry, just like the CAC. And so you're not going to court to file any application or anything. So when the nominee submits the proposal and the report to court, so the proposal, like I mentioned before, would contain the key agreement or the key things that will be proposed to creditors. It could be that, okay, all creditors, you have to take haircuts. If they're owing you 100 naira, you have to take 50 naira so that the company can survive. And maybe the rest of the 50 naira you'll be paid, you take up equity in the company. It could be that, okay, your debts were due in December because the company is facing cash flow issues, cannot pay all of you in December. Why not reschedule and let the company start paying, give the company some form of a moratorium, let the company start paying in February. Do you agree with that? Because if all of you move in, the company will collapse and you get nothing. It could also be that, okay, the company is not doing well at all and cannot pay in the foreseeable future. Why not take up shares in the company and then run the company? The business is viable. Maybe let's say after 1 year, you'll be paid dividends and then the dividends will keep coming and that will take care of your debt. So there are many things you can do, whatever you can think of, so far as it's legal. The process is a contract, it's a statutory contract. So whatever you want to do, you can think of so many things you can do, but the aim is to ensure that the company does not go down. So the nominee submits the proposal and report to court, and in that report it will state his opinion regarding the viability of the proposal. He has to state that the proposal is viable and is likely to succeed. Of course, if it is not likely to succeed, the nominee has the right to reject taking up. It's like a brief, saying, okay, I'm not going to take up this brief because I can't submit this to the court and state my opinion that this proposal is viable, which means it's likely to succeed. And then you also state in that report whether in his opinion the meetings of creditors and members should be summoned. And if in his opinion such meetings should be summoned, he will specify the date, the time and the place for such meetings. And it is instructive to note that the creditors meetings always come first. Both meetings can happen on the same day, but the creditors meetings would have to come first before the members meeting. That's what the law requires. So in the next page, I've listed contents of proposal. If you ever had any doubt about what a proposal is, it's as detailed as possible, the company's identification details, the reason for the CVA, you will state, as a nominee, you state the assets of the company. This is by no means exhaustive, but they are the key items you have in your proposal. If you go to the regulations 2022, you see a more detailed list of all the items, so you don't have to crack your head. And it's not even exhaustive. You have any other thing that you feel is relevant, you put it there in the proposal, because the idea is to ensure that when you place that proposal before creditors and members, they have a clear picture of the state of the company and the state of the affairs of the company. They are not misled in any way, because if they are misled, they can come around and challenge the CVA later if you file something that is not correct. So you have the assets of the company, you state the company's liabilities, and your fees. You have to state your fees, and of course you separate your expenses from your fees. And then the details of supervisor. If you're going to transition to supervisor, you have to state that you're qualified, because if you're not qualified, you won't be eligible to act as a nominee or supervisor. Other things are the timing and duration of the CVA, the dates for distribution of creditors, because the creditors will be interested in the timing of, you don't want to have the CVA in perpetuity. 10 years later, company is still in CVA. 10 years later, you've not paid the debt yet. It defeats the whole purpose of the CVA. Estimates of amounts for distribution to creditors, they'll be very interested in this, because these are items that will determine whether they would approve and enter into this contract with the company or not. How the business will be conducted in the course of the CVA. Are you bringing in certain experts to assist management, or you let them run the company? Are you going to take further credit facilities from the bank? Because it could be that the company just needs some form of refinancing. You put in money to make more money. And then the handling of funds, how are funds to be handled? Very sensitive, so that you won't end up borrowing more and then digging, the hole keeps getting deeper and getting the company into a larger or bigger mess. And other matters, like I mentioned, it's inexhaustive. You can check Regulation 2.02 of the Insolvency Regulations. On the right-hand side of that particular page, I've emphasized something here, a note to officers of the company and even nominees, that making false representations or acting fraudulently, because it's something that is possible to obtain approval of CVA. So packaging it in such a way that it's fraudulent, you're just doing it so that you sweeten it to make sure the creditors approve, without painting or giving them the true picture of the affairs of the company, can get you into trouble. The law provides for 1 year imprisonment for such false misrepresentation or fraudulent misrepresentation, or an option of fine. That's section 441 of CAMA. So the next stage is meetings and approvals. Recall, I have divided into 3 stages. We're done with the first stage. So after you've prepared the proposal and everything, and you submitted the proposal to court, not for the court's approval, just for the record, you now go into the meetings. You have to convene meetings of creditors and members, because their rights are going to be affected, so you need their consent. And recall, like I mentioned before, CVA has nothing to do with secure creditors. I hope we know what secure creditors are. Those people that secure their payment obligation with a property, maybe a collateral. So you borrow, let's say your client borrows money from a bank and then uses a land as security. So the bank is a secured creditor in that respect. But if it just borrows maybe amount that the bank considers negligible, and the bank does not take any security, whether it's movable or immovable, the bank is unsecured, and CVAs relate to unsecured creditors. So I've stated here that unless the court orders otherwise, so even though the court is to act as a registry, you're not meant to act the court or seek for consent of the court. The court can still look at the CVA and say, no, you can't proceed with it, or someone can even challenge it at this point, especially where you've gone beyond your remit to go and interfere with the rights of secured creditors or holders of preferential claims. Preferential claims in insolvency are claims by the taxman and certain employee claims. So unless the court orders otherwise, nominee convenes a separate meetings of members and creditors. How long do I have? Okay. So the meetings, and this again highlights the point I made before, that it's important for you as a nominee to liaise with the management and directors and meet stakeholders before this meeting. Because this meeting may reject your proposal and that's the end of it. It may approve your proposal and that's the desirable outcome. It may also approve your proposal but make modifications to it, and you do not want that because you now have to go back to the drawing table. So this highlights why you have to. The law does not mandate you to do that, but strategically you have to meet those critical creditors. Those creditors that you know their nuisance value is very high, they can come and then torpedo everything. You meet them to discuss with them and negotiate with them and get their buy-in before these meetings. So they won't end up rejecting it or making modifications that completely change the whole CVA, and then you have to go back to the drawing table. So in terms of approval, what is required at members meeting is 50% of members that are present at the meeting. Of course, if the articles of a company provide for another threshold, a higher threshold, then that would apply. So for creditors meeting, the threshold is higher. It has to be approved by 75% of creditors at the meeting. Note, like I said before, the creditors meeting would have to hold before the members meeting. In the case of TCN, both were held on the same day virtually, but creditors meetings were held before the members meeting. So, I've explained this already, that the meetings of creditors and members, they cannot approve or modify proposal which affects the right of secured creditors, and I've been emphasizing that CVAs have nothing to do with secured creditors. That's its limitation. So if your client's problem is with secured creditors, CVA, you cannot go to settle or to solve it by virtue of a CVA, because a CVA cannot alter or modify rights of secured creditors. It only deals with unsecured creditors. I've already also stated that you cannot alter priority payment for preferential debts. Preferential debts are debts owed by to the taxman and certain employee claims. Right, so we move to the next slide, and this is the last stage of a CVA. So after you've gotten your approval by both the creditors meeting and the members meeting, you're ready to go, you're good to go. So whatever you've put before them, the proposal, and they've approved it, you have to now implement. At this stage of implementation, if your client retains you, the company retains you, and if the creditors are not insisting that it should be removed, then you transition to what is called a supervisor. The qualifications are the same. In practice, nominees simply become, for convenience, supervisors, because they would have known the transaction and the proposal very well. No need to bring in, unless maybe some creditors are not comfortable with you, or maybe there's some form of conflict, then you have to step aside for someone else to continue. So the supervisor implements the proposal, whatever proposal is there, whether the proposal says that, okay, all creditors, none of their debts should be paid in the next 6 months. Let the company generate enough income and start paying after 6 months. Or all creditors, they should be paid out of every 100 naira, they should be paid only 50 naira, and they'll take a haircut. That way, at least everybody gets something. Or all creditors, okay, if you're owed 100 naira, you get 80 naira in equity, and so your debt is now reduced to 20 naira. So the proposal is just anything that has been decided, the duration, that this is to be done, how the funds are to be handled, all the items we had considered before in the proposal. So once it's approved, what now happens is that it becomes, like I mentioned at the beginning, when I was describing a CVA, it becomes a statutory contract, agreement, and a binding agreement between the company and the unsecured creditors. So someone can go to court to enforce it if the company defaults. Of course, there are other remedies available to unsecured creditors where the company defaults in implementing the proposal. So the effect on unsecured creditors, it's binding on all unsecured creditors. Section 439 sub 2 paragraph B of CAMA says it binds every person who was entitled to vote at the meeting, whether or not he was present or represented at it. So if you're given notice and you refuse to show up, believing that, okay, since I wasn't there, it will be binding. Once it's approved, it's binding on you, so long as you're an unsecured creditor. He said, binding on persons who would have been so entitled to vote or attend the meeting if he had notice of it. This is a controversial provision because a company can simply rely on this and not give notice to, maybe a creditor that it feels will come, the nuisance value is high, and then rely on this subsection to say that, okay, well, even if you didn't get notice, it's binding on you, so long as the majority at the meeting has approved it. I mean, these are issues that would probably have to be litigated, and then the court will decide whether how fair they are or reasonable these provisions are. Effect on unsecured creditors, of course, it has no effect on secured creditors, cannot affect the rights of holders of preferential claims. So consequences of implementation, the nominee implements, directors and management remain in office, and that's why they call it a debtor in possession procedure or process, because the debtor remains in the office, unlike in liquidation or receivership, where the management is displaced or they are at the mercy of the receiver or the liquidator. Of course, there is going to be a payment plan. There could be a payment plan, and the company must follow that strictly. So it agreed, it's a binding contract, and it must adhere to the terms of the agreement. Most times, this is not in the law, but in practice, it's advisable because the company will continue trading, and monies will start coming in. So it's advisable during this period to set up maybe a trust account, a separate and distinct account. You can call it a CVA trust account. What this does is that there have been circumstances or cases where a company in CVA subsequently becomes insolvent through maybe any circumstance. So if it becomes insolvent, the unsecured creditors could be left in a worse state because they've forgone certain rights. They may have even pumped in more money, agreed to, refinance and contribute more. So creating a trust account ensures that in insolvency, the liquidator would not come close to that account because that trust account does not belong to the estate of the insolvent company. I don't know if you understand. That's an insolvency. It's one of the exceptions to the rule that a liquidator is entitled to grab the assets of the company, and it's not really an exception because an asset in a trust account does not belong to the company. It belongs to the beneficiary. It's like assets that are subject to security. A liquidator cannot grab those assets and share them to unsecured creditors. So it's advisable to create a trust account when the company starts, continues trading after the proposal has been approved and at the implementation stage, so that if insolvency subsequently occurs, the unsecured creditors will not be left in a worse situation. At least they will have something to look up to, that this trust account does not fall under the estate of the insolvent company, and they can share that among themselves. Okay, so we're looking at grounds for challenging CVAs because the law recognizes that people may be aggrieved. So it's not a cramped down kind of arrangement that, it's going to be forced down the throat of all unsecured creditors. There may be circumstances where some unsecured creditors may feel, that they've not been fairly treated, or that they would have been even better off if the company had been liquidated. So what's the essence of having a CVA? If in a liquidation, I would have had a better deal, or in terms of distribution, I would have had more. That means I just wasted my time going into this arrangement. So there are two grounds. The grounds for challenging a CVA is very narrow, and this is in line with the spirit of this law, trying to make this process as less formal as possible, so that it's not at every instance or irritation you rush to a court to air your grievance. So there are two grounds that you can challenge a CVA as a creditor if you're representing an unsecured creditor. First, you can challenge a CVA on the basis that you've been unfairly prejudiced. If you look at the slide there, you see one that is unfairly prejudicial, that it's unfairly prejudicial. And there are two ways you can go about this. It can be what is called horizontal prejudice. So horizontal prejudice is where you believe that as a creditor, that you've received less favorable treatment compared to other unsecured creditors and without any business justification. You see that many hurdles along the way. It's not just saying that, oh, okay, Mr. B got 20 naira out of 100 naira and they gave me only 10 naira out of 100 naira. If there's a business justification for that and the nominee and supervisor can justify why they took that decision, your challenge may not be successful. But what you have to bear in mind under this subheading of unfair prejudice is that you're simply going to court and telling the court that, look, we are all unsecured creditors. Why should B receive more than me? I'm being unfairly treated. The other subheading under unfair prejudice is what's called vertical. Of course, if you have horizontal, you have vertical prejudice. So vertical prejudice is the one I described earlier. You're simply complaining that, look, if this company had been allowed to go into liquidation, I would have gotten more. So now you're doing a CVA, I'm getting less. Let's say in liquidation, I can prove that I would have gotten maybe 50 out of 100 naira, and here you're giving me 30 naira. So of what benefit is this process to me? May as well put the company in liquidation rather than go through this process and I get less. I've listed one example there, guarantee, what is called guarantee stripping. Here you would have a situation whereby, let's say a creditor gives a loan to a debtor, and the debtor has a parent company who has given a guarantee that if the debtor does not pay, I as a parent company, or maybe I as a director of the company, will pay the debt. And then in the CVA, what now happens is that that guarantee is taken away and you're given less. You can challenge that CVA on the ground that, look, if that company had gone into insolvency, I would have gone to that director and told that director, oh yeah, pay me everything. You gave a personal guarantee. Or I would have gone to the parent company or affiliate. You gave a corporate guarantee. Pay me everything. I don't want to be part of this insolvency. And you wouldn't be stopped by the liquidation process. But here you are in a CVA. You're not getting your full payment because that guarantee has been stripped and you're getting maybe 40 naira out of 100 naira. I think that's a clear example of vertical prejudice and guarantee stripping under vertical prejudice. That you can challenge a CVA. We are on the first one, unfair prejudice, that you've been treated badly. Either you've been treated badly compared to your fellow unsecured creditors because they are getting more. You've learned from the grapevine that they are getting more than you, but you're all similarly situated. So why are they getting more? Or that you're claiming that, oh, in liquidation I would have gotten more now, so why am I in this thing and getting less? That's unfair prejudice. The second ground for challenge is on the ground of material irregularity, and this is the part that will be sweet to many lawyers because we are very technical and procedural when it comes to litigation in Nigeria. So many booby traps. So here you're simply challenging the process on the ground that a procedure which ought to have been followed, maybe during the meeting or anything, convening of the meeting, summoning of the meetings, or at the meeting, was not followed. This is sweet music to many of us. So you can challenge on this ground. But bear in mind that Nigerian courts, like I told you before, this CVA did not lie from space. We borrowed it from England, English courts. They've developed a test for this material irregularity. And the word material comes to fore now. Whatever irregularity that you're relying on has to be material. And the test for materiality can be very tricky. So you have to show that in the absence of that irregularity, maybe, let's say, a particular information was concealed from creditors or members. And you have to show that if that information was made known to them, they would have voted differently. So you have to show that that irregularity is material and went to the root of the whole process. I've quoted, well, it's not a quote, it's from Debenham's Retail, one of the cases in England. He said an irregularity will only be deemed material if had the irregularity not occurred, exactly what I said, it would have made a material difference to the way in which the creditors would have had to consider and assess the terms of the CVA. Another case here involving Cadbury, 2001, said an irregularity is material if, had the truth been told, it would be likely to have made a material difference to the way in which the creditors would have considered and assessed the terms of the proposed IVA. This has to do with individual voluntary arrangement, but in principle it also applies to companies' voluntary arrangement. Of course, if your challenge succeeds, there are a number of remedies that are open to you. But you have to make your application, your challenge, and this is another procedural issue. The law requires you to make your application within 28 days of when the chairman of the meeting, which is usually the nominee, submits the report to court after the meeting. So if you stay beyond the 28 days, the law is silent as to what your fate will be. But trust Nigerian lawyers, I'm sure people will be seeking for leave to still challenge. So, the applicant who can challenge, of course, this again, sweet music, Nigerian lawyers, the issue of local standard, which we talk about every now and then. You have to be a creditor or a member to be able to challenge. You can't just be a meddlesome interloper to challenge. You have to be a member. And it's understandable because these are the people that the CVA would affect their rights. So a successful challenge may lead to a revocation of the CVA, and I'm going to explain the difference between termination and revocation. Very important. It could be to a suspension of a decision approving the CVA, suspension of the decision by the meetings. It could also lead to the court ordering the summoning of meetings. Let's say there were some procedural irregularities in meetings, maybe the way notice was given, so you can order for the meetings to be held again. They can also order for a revised proposal to be submitted, or even a reconsideration of the original proposal so that it's done properly. Of course, there are other remedies outside the law which one could explore. If you are an unsecured creditor or your advisor an unsecured creditor, the commonsensical one is voting against it if you are aggrieved. And if you have the numbers, you can succeed in ensuring it doesn't go through. If it's going to affect your rights adversely, of course there can be a right to terminate. If it's a contract, then there should be a right to terminate the contract. But this could be limited because the proposal could set out ways in which, or provisions or terms that would make it difficult for an individual to terminate, because it's seen as a contract between unsecured creditors collectively and the company, not individually. Or else someone will wake up in the morning and say, I'm not doing it again. So it has to be a collective decision to terminate, which can be very difficult because it's difficult to have people on the same page most times when it comes to debt recovery. They say creditors act irrationally. Everybody thinks if he moves first, he'll be able to recover as much as possible, irrespective of what happens to the others. Okay, so there is also the risk that even after the proposal has been approved and then we are at the stage of implementation, the supervisor defaults or the company defaults in implementing. So you've agreed that you're not going to do this, you're not going to carry out certain transactions which were detrimental to the company, or the creditors and members considered were detrimental to the company, and you go ahead and do it, or you said you were going to make payment from March, and this is July, you've not started making payments yet. You've defaulted on the implementation of the CVA, and the law will not leave creditors and members or creditors without remedy. So what are the options open to creditors if there's a default in implementation? The CVA itself, that's the proposal. Creditors can, in the proposal, specify events of default and then the remedies that will be available to them if there is a default. It could provide that if there's a default, that's the end of the story. The CVA comes to an end, and then they move in to distribute the assets of the company, although that's quite extreme. It can also empower creditors if there's a default and there's nothing there for them again, instead of them waiting in limbo and in perpetuity, to proceed to file for liquidation, so file your winding up petition. Of course, there's also action, like I said, it's a contract. So you can have your action for breach of contract and seek for damages. It could also give them the right to terminate. I did mention that I'm going to distinguish the difference, or I'm going to highlight the difference between termination and revocation. If you look at the slides, I've done like asterisks there. I didn't want to forget that. So you could give the right to terminate, you could give the right to revocation, which may not have the same legal effect. We'll look at that in the next slide. And of course, if there are complaints against you as supervisor, the creditors also have remedy. They can approach the courts, to reverse certain things you've done. If you end up doing things that were not in the proposal, you just take your own course and you decide to behave anyhow and act anyhow. You can approach the court. Like I said before, it's meant to be informal, but this is where it becomes tricky, where it is challenged, or where people misbehave. Of course, the law gives people remedy. People are not shut out from the court. They can approach the court to challenge the actions of the supervisor that, look, you're not implementing what we proposed and agree. You're doing something else. You're on your own, going on a frolic of your own. So the court in that instance can give direction on how the supervisor is to act and make such other orders as it deems fit. So the next slide, I guess some of you are ahead of me because you control your slides. I like controlling my slides, so you will see what's on the next page. So termination and revocation. So the problem with giving the right to terminate or without revoking is that you could terminate, but some things may still be ongoing. Take for instance, you terminate a CVA and then you do not revoke. What would happen is that some rights and liabilities that have accrued, may go on, and a party in future may go to court to claim those rights. I've listed 2 cases here to highlight the example. In SHB realizations, what happened there was that the company entered into a CVA in March 2016. It was terminated in December that year. And there was a clause 5.5.9. It said, and this one made it very clear so that there's no confusion that, termination may not amount to revocation. It says, upon termination. Because when you look at this, you say, termination is meant to have this effect. No, not correct. It says, upon termination, the compromises and releases effected under the terms of the CVA shall be deemed to have never happened. Because if you terminate and the compromises and releases are still there, certain agreements that were in place are still there. Like you have in your contract, you say, the fact that you've terminated does not affect accrued rights. Someone can still insist on some of those so-called accrued rights. So any compromise that was entered into by the creditors, any releases that were made, I'm going to forego this, I'm going to take this haircut, all of them are gone. That's what revocation does. So that it will be deemed that nothing ever happened. To do with a suit to revoke an already terminated agreement. Okay, wrapping up now. So, the claim against supervisors. So there was a claim against supervisors, the lawyers, for fees and costs of administering the CVA. A tricky one. The creditors were like, since the CVA wasn't going anywhere and it's been terminated, all our fees that we paid you, you have to pay us back. You can imagine a lawyer being faced with that kind of claim. Even after doing the work, they said, it's terminated, but you did nothing for us, and we need our fees back. Because without paying us our fees, you leave the company in a worse situation. So the supervisor argued that termination practically had the same effect as revocation, but the court disagreed with him. The court said that revocation was distinct from termination, and that certain terms of the CVA, like I said before, may survive termination. Merits of the CVA. And I will lay less emphasis on the shortcomings because I'm selling a product to you. I'll just tell you some of the shortcomings, but not all. So in terms of the merit, the directors remain in control. Of course, someone would argue that if the directors were responsible for the company going down, keeping them in control would be counterproductive. You're absolutely correct. Of course, the proposer can also, if that's the case, it can suggest that the directors or management should be kicked out. There's nothing wrong with that. Although it is naturally a debtor in possession process. So, but the advantage with management remaining in control, like I mentioned before, is that trading operations are not disrupted. Companies' operations, that's the second item, not disrupted, continues trading. Members can make input, unlike in administration and liquidation, where members have little or no say. The creditors are completely in control. It leads to reduction of it may lead to reduction of companies' debt. It's flexible. I've mentioned several types of things you can think of, so long as it's legal, they can do in a CVA. May cut costs, boost cash flow. Privacy also, unlike liquidation, that you go to newspapers and advertise the petition. Same with administration. There is no such requirement in CVA. And that's why you won't see advertisements of CVA or even see them in the news unless it's linked to the press. So it gives that privacy and there is no stigma accompanying it. That's the last point there, less stigma and reputational damage. Still on, you can see the rest of the merits. Another page of merit, unsecured creditors are paid. Does not require company to be insolvent. So you can start the process even before the company becomes insolvent. Unlike liquidation that you have to, if you go and file a winding up petition, you have to show that the company has not been able to pay its debt as it's fall due, and that debt has to meet the threshold as specified in CAMA. It prevents filing of winding up petitions. So once it comes into force, it's binding on all creditors, so unsecured creditors. So nobody can go out and do something else. Simple and uncomplicated. You may agree with me based on what we've discussed so far. Relatively informal or less challenged. Emphasize that severally. Less expensive than administration and even liquidation, and binds consenting and non-consenting creditors. So it consolidates debt into one single payment, which is quite simple and makes it uncomplicated. So all 100 creditors come together, and then, so what is paid is one single payment, which is distributed to so many creditors. So it's not bothered, the company is not bothered about paying A in Lagos, B in US, this one in this. All the debts are accumulated, and one single payment is made into the account, and the supervisor makes the distribution. So it makes life easy for everyone. The shortcomings are here. You can see them in the slide. Not binding on secured creditors who may do whatever they want to do. For instance, if the company is one that is dependent on a particular machinery to survive, and that machinery has been given as security, a secured creditor can grab that machinery, and that puts an end to the company. No moratorium, which is very important. Unsecured creditors can still do what they want to do. Directors remain in control. I've highlighted that before. It has a flip side. So the duration is not specified in law. Okay. Say I have 1 hour more. I'm joking, 10 minutes. I'll be done before 10 minutes. No duration specified. But in the proposal, it's your duty as the nominee and supervisor to provide. If you don't provide duration, no sensible creditor would even approve it. Because nobody wants the company to be in CVA in perpetuity. So you have to specify the duration. Typically, it could be between 2 to 5 years. So creditors may be worse off if CVA fails. Adverse effect on companies' credit rating. So even if you're not publishing it, people will get to know, and then you may have problems with some. This just goes round. So by the time you want to approach a creditor a supplier. The company approaches a supplier to supply goods of credit. You say, no, you're on CVA, it's going to be pay on delivery. I'm not going to give you any credit facility. What if the CVA does not go well and tomorrow you become insolvent and I become a creditor? So it's pay on delivery. So that can still happen in spite of the fact that it's not published and all that. May adversely affect cash flow because you're restricted in terms of what you can do with the money you have at the company this time. Difficulty in ascertaining unascertain claims and even prospective claims, and may trigger insolvency default clause. This is very important because you see all those contracts, when you draft them, they now prove that if there is any event of insolvency, this contract is terminated. So this is a formal insolvency process. So going into CVA may trigger those insolvency clauses in other critical agreements, and those creditors may decide to terminate, and that may adversely affect the company, especially in contracts that are critical to the company. So here I told you about the first CVA in Nigeria, Tourist Company of Nigeria. The CVA proposal was dated 30th August 2021. You'll see it in the slide, so I don't have to really go through this. It was facing cash flow challenges resulting from COVID-19 restrictions. Its revenue fell from 7.7 billion in 2019 to as low as 1.13 billion in 2020. And then the CVA was proposed by the directors. And one of the significant proposals it was making to creditors was for them to waive accrued payment and payment of interest for a period of time, agreed time. And I read this proposal, it didn't state the time. I mean, typically creditors wouldn't accept this, but this was a peculiar one because the creditors were all affiliated to the company, so it was easy for this to sell. I've listed the creditors here, Eket Hotels PLC, Sun, all of them were affiliates of this, so it was easy for that to sell. I've stated what the nominees report that was submitted to court stated. He stated that the proposal was viable, like I mentioned before, what the nominees report is to state, and fair to creditors, and there was reasonable prospect that it be approved by creditors, and of course it also recommended that the meeting should be held and where the meeting should be held and all the other formalities. So this is a timeline. I'm not going to go through it. The timeline for the Tourist Company of Nigeria, the CVA, proposal 30th August 2021. If you notice, the second and third item, I put them in red because you're going to ask, so why did they go to court to seek for an ex parte application? What were they looking for when it's meant to be informal? Of course, it was a test case, and back then the regulations were not on ground and they didn't have the infrastructure to run it like a classic CVA. So they needed guidance and directions from court all through. So that's the negative part of making this a guide in terms of CVA, because with time, what the CVAs, infrastructures are now on ground and they can do without necessarily running to the court at every little instance to get guidance and in order to protect themselves in terms of the nominees or insolvency practitioners. So, publication of outcome of meetings, members' meetings and all that. So they're all in the slide. I suspect, okay, so the last slide here is just further recommended readings if you have the time. 2 articles I published in this day, one 2020, the other one, I can't see the date here. One is titled An Overview of Company Voluntary Arrangements in KAMA 2020. The other one is A Preliminary Appraisal of Nigeria's First Ever CVA. That dealt with the TCN. So if you Google this, just search on Google, you find they will pop up there. They are free on Google. Thank you so much. That's the end of the presentation.
Please, I will give you a round of applause. Now, let us give a standing ovation. Please, gentlemen, continue giving a round of applause before he sits down. Thank you very much, John.
I was imagining how he came to be in such mastery of the subject matter. It's amazing, Dr. Lofia. I'm really impressed. Thank you very much. I thank the NBA once again because this regime is just about 4 years. Just about 4 years old. Those of us who went to school a few decades ago, let me say, we are hearing this for the first time. Except those who were called to bar 2-3 years after 2020. This will find its way into the syllabus of curriculum of the recent years only. So, Eket, kudos to you once again. Thank you. good to get to novel areas, things that are new, and I think Eket is always a record-breaking place. The bar is a record-breaking bar. You don't have broken records, existing records, and breaking this about. Okay, thank you very much. Let's have reactions. These reactions will be by way of, if you want to make comments. If you want to comment Dr. Udofia, you can still do so. It's going to be permitted by me. Okay, thank you.
My Lord, I'd like to commend the speaker. Beautiful presentation, simplified. You don't even have to be a lawyer to understand what you were talking about. And in the course of your presentation, it opened my mind, and I was able to come up with some things with this introduction of the CAMA 2020. And I say it gives a soft landing to companies who are about to suffer insolvency. It also opens opportunity of rescue procedure by introduction of the company voluntary arrangement. I also said unsecured creditors feel protected, and it gives an opportunity or second chance to companies who are about to go through any kind of insolvency. It also, like you said, allows companies to maintain their structure because it gives confidence to maybe the unsecured, creditors and also maybe their shareholders as well. It also helps to decongest the courts. That's one thing that the advantage it has over CAMA 1990. And again, the one that I like so much. It opens career opportunities for lawyers and professional bodies. Thank you very much, Doctor. You've done it.
Doctor, before I ask for another, I want to ask. You were emphasizing on the fact that the regime, the CDA, does not apply to secured creditors. What about consent? What about their consent? If they provide or give the arrangement, the consent.
Absolutely, my Lord, and thanks for that. So they can actually consent that their rights should be interfered with. That's the only circumstance that they can interfere with their rights. So you're absolutely right.
Thank you. So secured creditors can be involved with their consent. That's a position. All right. You want to comment? Yes. All right.
Mr. Chairman, let me see my passage to say this. Yes. Let me start by commending the speaker on the very comprehensive paper in an area we see as a rather very novel area for those of us, as the Lord pointed out, who went to school 100 years ago. He has handled it very comprehensively. The beauty about insolvency law relates to efforts being made to salvage dwindling or tottering corporations. Yeah. Those are the beautiful things in the law. The provisions are being made for how tottering companies can be salvaged, such way as restructuring their credits or debts that they had. But the novelty of this law that should attract some areas of concern. First of all, for us lawyers, the new area, it opens a travesty for those of us who will be concerned to interrogate the provisions of the insolvency law. Well, let me relate the kind of life situation that I personally experienced. But one, the corporate organizations that are not properly set up what happens in a situation where suddenly the director or the chairman of the company dies? They do not have sufficient number of directors to be able to follow the provisions that should be able to exploit the CVA. That is good. And one arrangement is maybe consultations were being made to maybe invite lawyers to see how the company could be rescued. Relations of the owners of the company now took laws into their hands. I'm talking about the live situation where they attacked the premises of the company, dismantled the structure that housed the operations of the company, sold off to the company, and then you are being asked to go to court to handle the situation that was not foreseen by maybe surviving directors of the company, so that they could now make arrangements for how creditors of that company could be paid. That is, in fact, for me, is a live situation that is presently being handled in court. Because one of the issues that will face us is that in this area, most of the directors of the companies we have are hardly well educated, and some companies do not also take steps to make sure that they follow the provisions of the company in terms of the number of directors. Somebody is able to set up a company, brings in his brother, cousin, that kind of situation. And this is what was responsible for the situation I'm talking about, of relations of the director, their director, intervening, taking laws into their hands, and not being aware or not being willing to exploit the provisions of the CBE to handle the situation. What is the remedy that is easily available for the creditors of the company who may not now have assets to resort
My understanding is that creditors do not have access to the company and any information useful to them in terms of maybe company statement of affairs. So the creditors have to be more proactive. So they have two options. Like I mentioned before, the directors can propose a CVA, and when they fail to do so, the creditors can also do that. So they ought to have proposed the CVA, and if they believe that the company or whoever is behind the company wouldn't be cooperative, they have other options. I mean, the CVA mustn't be a do or die thing. It must be a CVA. Other options will come handy. I mean, it could be a winding up process, just one, and it's valid. I mean, just one twist them and make them behave. It could be maybe a phasing order to stop the assets from being dissipated. So it must not have to be a CVA. It's only when it's useful. They have to consider their choices, and the lawyer will properly advise them on which one is most suitable. But it must be a CVA, because we don't have access to the company and the statement of affairs. Then there's nothing they can do in terms of the CVA.
Thank you. And also, please, there are briefcase companies. Too many briefcase companies. Some of us, we incorporate companies, and that's the end of it. No returns. You don't file returns. The CAC does not even know this company again. The company and everything about it was left since in limbo. And you were supposed to file annual returns before you are recognized. What we are doing here is for companies who are filing returns. We are not here for mushroom pocket companies that have no residence, that have nothing. Not even a return of address. You don't have return of directors. You don't have annual returns of your turnovers. I mean, you just went to CAC, deceived CAC, received these things, and you call it, you have been incorporated, and you run your business throughout for years. Even some people will be dying from your original filings, and and the CSC does not know about. I'm not here for that kind of company. If anything happens, whatever you find, you go to court, in fact, go to even criminal court, sort it out. But ensure, lawyers, you also have companies and your advisors too. When I see cases coming to court, maybe claiming filing for claims, in civil claims, and you have the name of the company and then maybe the managing director. Sometimes that managing director is the sole director, is the sole everything. There's no other person, you know, not that kind of company. So when you are briefed by these persons, inquire into the viability of that company, inquire into whether they have been filing annual returns. Don't bring companies that have not been filing annual returns to my company.
Okay. Mr. Chairman, discussants, my understanding of this CBA is basically, I think it will work in this major situation where the insolvency is unforeseen. But I don't think it will work where there's incompetence. Because I think, as a lawyer, I will not allow my client that is being owed money to enter this kind of arrangement unless we have some control over the affairs of the company. Like, for instance, I think the best arrangement would be a kind of hybrid arrangement where we will have some of us being directors or having access to the financial control of that company. Thank you very much.
Also, before you make your contribution.
Somebody started shaking of landmark attorneys, but soon I road Eket. Please, I want to stand on the register of the protocol and appreciate the Dr. Dofia, who has made a very articulated presentation today. My line of question is coming from this side. I like practical example, like the case of Heritage Bank that we recently witnessed in Nigeria. Please, I wouldn't know if, I would like to know if this insolvency law applied to Heritage Bank in terms of as regards winding up of the bank. Because when that happened, it came as a shock to many of us. And we saw the premises of the Heritage Bank being barricaded by a lot of customers and creditors, whether secure or unsecured. Please, my question is this. This company came in 2020. I wouldn't know whether the provisions of that CAMA was effective, were effective in protecting the customers of the Heritage Bank. And secondly, was it that Heritage Bank got worn up by insolvency or inability to meet the capital base as prescribed by CBN? 2. Then, was the assets the asset of Heritage Bank, was it enough to meet the entitlement of the creditors of the bank who were caught up by that winding up? The next question is whether if the asset of the Heritage Bank was not enough to meet the entitlement of the creditors, whether secured or unsecured creditors or customers of the bank, was there any arrangement or is there any arrangement in CAMA that ensured that the investors or creditors of the Heritage Bank were able to be taken care of financially as regards the deposit they made in the bank? Thank you, sir.
Thank you. In relation to the first question, you said you would not be, you not want your client to be involved in an arrangement where management or directors remain in control, because basically the company would have been, it's likely that the company would have gotten into that financial mess due to incompetence of management, right?
Yes.
Okay, so
Except for the fixed this major situation?
Yes, so a CVA would still be useful in that scenario. How? Remember I pointed out something that leaving management in control has its advantages and demerits. The advantage is that business is not disrupted, trading continues and all. But the flip side is that I highlighted the fact that if they were the cause of why the company has gotten into that mess, then it becomes counterproductive. So the solution to that is that you have your proposal. I highlighted the fact that the CVA is very flexible. You can do whatever you want. So as a creditor, you have that leverage to insist maybe in the proposal that management, either they're going to be supervised by external people, your nominated consultant, or you can even kick them out. Though it's called debtor in possession, you can bring in your people to manage. That could be the bargain you want from the company to support the CVA. Yeah, so you have that leverage. Okay, so the second question has to do with Heritage Bank. And to start with, karma does not apply to insolvency of banks or resolution of banks. Resolution of banks, you don't say rescue or you say resolution, the same thing as rescue of banks. The Banks and Other Financial Institutions Act, BOFIA, I think 2020, it was reenacted or revised same year as karma, and then the NDIC Act 2023, those laws deal with insolvency of banks. So bank insolvencies are not treated the same way as company insolvencies. You can't even file, I know we did that some time ago, before BOFIA was revised, we filed a winding-up petition against a tier 1 bank, UPA. It didn't see the light of the day, but BOFIA is now very clear. You cannot even file a winding-up petition against a bank. I mean, it's to ensure stability of the financial system. Only CBN can revoke a license of a bank based on conditions set out in BOFIA and then hand the bank over to NDIC, Nigerian Deposit Insurance Corporation, that is the body designated to liquidate banks. So it's quite different. The thresholds are quite different. It's not the same as, okay, being unable to pay its debt. When CBN revoked the license of Heritage Bank, the grounds were, they situated the reasons or the grounds in BOFIA that they were not able to meet their financial obligations. Of course, I knew what Heritage Bank, I knew the bank intimately. I don't want to go into details, but some of the things, some of the challenges they had was they weren't even able to pay some customers. At some point, you want to go and, some depositors, you want to go and withdraw your money, they tell you to come back, and they had obligations to other banks, like FBN, which they were not able to settle. So the best bet, and like I said, it's a different regime. The best solution for CBN then was to take it out of the system, because the longer it remained there, banks have interrelated transactions. The failure of one bank can mess up the whole financial system. So the best thing was to get rid of it. They had the option of rescuing it, bringing in Amcon to do it, like they did for Skybank, Polaris. But in this case, they decided that it was best to take it out. And unlike, another point I have to highlight is that unlike liquidation of companies or insolvency of companies, when it comes to bank resolution or insolvency, CBN's priority is depositors, not necessarily creditors. Depositors are usually paid first, but there's a threshold, up to a certain threshold. So it had nothing to do with not being able to pay its debts to minor creditors, and as they fell due, they were facing serious financial problems, and CBN thought that if they left them operating, it would lead to some form of systemic risk, which could affect other banks because they have interwoven transactions. I hope that's clear. Thank you.
So then we close.
I'm sorry, everyone. My question is, in practical terms, how does the CBA differ from the traditional insolvency procedures like receivership and liquidation? And secondly, is this CBA, is it also, how can the small and medium scale businesses, how do they benefit from it? Thank you.
With the leave of the chairman of the session, may I start by commending the presenter for a very detailed presentation. I think he has done very well. Now my question is to the role of AMCON in winding up procedures. Why do some companies attract the intervention of AMCON during the time of liquidation and some do not? What is the role of AMCON in winding up procedures for companies? Thank you.
Chairman, my name is Samuel Ajoba. I was also thinking in the direction the last speaker just spoke. But I want to add, with the provisions in the laws for CVA, what will AMCON really be doing in winding up the receivership, etc., of companies that are insolvent? Because it seems that the companies can actually take care of themselves with CVA if they are challenged. So if they are able to take care of themselves when they are insolvent or when it appears that they will be insolvent, what will AMCON really be for these companies? Either to stay afloat or to die?
Thank you, my Lord. So the first question is how does CVA differ from receivership and liquidation? So the first significant difference which I highlighted is that CVA is a debtor in possession process, meaning that management stay on and oversee the process. Of course, there could be a provision for management to vacate, but naturally, management remain in control. That's one difference. Compared to a receivership that you have to appoint a receiver, an external person, an insolvency practitioner, and in liquidation, you have to bring in a liquidator. That's one difference. The second difference between a CVA and liquidation is that in a CVA, you don't have to wait for the company to be insolvent. Once the early signs are there that the company is in trouble, without even being insolvent or meeting the threshold for insolvency, you can initiate your CVA. And that's why we say CVA can prevent a company from becoming actually insolvent. Unlike in liquidation, you go to file a winding up petition, you have to show the court that the company is actually indebted to you, in a certain sum, and has been so indebted, you made your demand, send your statutory demand. 3 weeks afterwards, the company has not been able to pay and all that. So for CVA, you don't have to wait for that. So it's it can also be seen as a preventative insolvency process. And again, CVA is more like it's not an adversarial proceeding or process like litigation. It's the same kind of fight you have when you go to wind up a company. By the time you file a winding up petition, the other person throws in a preliminary objection just to open a route. If it's decided against him, you go on appeal and apply for stay. If it's decided in his favor, that's the end, and the fight here and there. Receivership, same thing, appointed out of court, someone goes to get an injunction, or you appoint in court and then you fight. So, but a CVA is more like a mediatory, it's a negotiation. So, at the end of the day, relationships are managed and not damaged. So there are many more examples I can find in the slide. Okay, so the other question was, how can SMEs benefit from, how do SMEs benefit from CVAs? The answer again lies in the previous answer I gave. It can prevent them from actually going or becoming insolvent, because once the early signs are there, SMEs can, in fact, SMEs are, CVAs are better suited for SMEs who may have legacy debts. SMEs who may not have so many unsecured, or may not even have unsecured credit, or secured creditors that can disrupt the process. So they can take advantage of CVAs even before they become insolvent. They do not have to wait to become insolvent. Like I said before, it's not adversarial, it's non-adversarial. They can negotiate themselves out of trouble.
the stigma of publicity is not there, and they can manage their relationships with their suppliers, their creditors. So even after the process, they can continue running their business smoothly and maintain that cordial without burning bridges. So there are several examples and several advantages. Those merits I pointed out in the slides, 2 pages. You can look at them, and those are all benefits of CVAs to SMEs. Then someone asked, what is the role of AMCON in winding up? Why do some AMCON intervene in some companies, or some companies attract AMCON and some don't? This is actually not within the scope of this work or this discourse, but what you have to bear in mind is that AMCON does not just go after any debtor. If you look at the AMCON Act, AMCON is a body set up by law. There's AMCON Act, which was enacted in 2010. It's been revised several times, 2015, 2019, I think the last revision was 2021. If you look at it, you see the powers of AMCON. They go after many debtors of banks with what is described in that law as eligible bank assets. So, in fact, AMCON, as at now, they've stopped buying those debts. What they are chasing now is debts that were they've drawn a line. They're not buying debts again, except maybe recent banks that were taken over, like Polaris, Skybank. So they go after the debtors of those banks. Back then, when it was established, it was to take care of the messy system because there were so many non-performing loans. So they brought them in that vehicle in to buy all these debts of the banks, clean up the book of banks, and go after the debtors of the banks, the eligible bank assets. So those are the ones that are going after. They don't just wake up from sleep and start chasing or deciding which bank debtors to chase and which not to chase. Those debts have to be qualified as eligible bank debts or bank assets under AMCON Act. And they are not buying it. Right now, people are saying, look, AMCON is not meant to exist in perpetuity. It used to have a sunset clause where it's meant to end once it finishes past. So it's dissolved. It's been extended, but the idea is at some point AMCON will be dissolved. So Mr. Ojoko asks, what is AMCON's role in CVA? AMCON, to be honest, the way it is, AMCON would not necessarily be inclined to CVA because under AMCON Act, there are many more efficient and effective tools for debt recovery. And the AMCON Act places AMCON even, it puts it at an advantageous position, even more advantageous than secured creditors. So I don't see why AMCON should want to be a part of CVAs. It gives them the powers to appoint receivers. It gives them the powers to make freezing orders. It gives them the powers to, in fact, one of the powers AMCON has under the, I think, 2021 amendments is that if I use this phone, if I've given this phone as security to a bank, I've collected a debt from a bank, if that debt is an eligible bank asset that AMCON has bought, AMCON is not just restricted, to this phone. It can come after any of my assets. So those are the kind of extensive powers AMCON has. So the CVA, they wouldn't even want to, and they are in a hurry to recover debt, and they wouldn't have that patience to start, going under CVA and doing all this. So it goes back to the issue of the essence of CVA, that it would be most beneficial to SMEs who may not have huge loans they are owing to banks, the type of loans that AMCON would go after, billions and billions of naira or dollars. Thank you very much.
Ladies and gentlemen, thank you for all your attention. Mr. Chairman, MEA, Mr. Chairman, Planning Committee, thank you. Our work is done.
And the chairman of the branch, we want to thank Arnold for being with us today. And we want to also thank Dr. Udofia for being with us. With the kind permission of the chairman, I will declare Dr. Udofia an associate member of this branch. So, Doc, from time to time we will be consulting you. And I know that you are always around within our jurisdiction. So we will consider, I will now go to the court and spy the days you have matters here so that we can fix our elections. Thank you very much for coming. Therefore, Chairman, thank you, sir, for being with us. Madam Mrs. Moji, thank you very much for being with us. The Chairman of the session, sir, by our protocol, we will take group photograph. Ushers, go and assist members to sit down. The members you see, just hold them, let them come and sit down. Where are the ushers? The microphone. Please, can we be giving her a round of applause? Such an elegant. Good to see you. And how are you doing?
Thank you very much, Chairman, Planning Committee. You've done noble, sir. Thank you. Good afternoon, everybody. Good afternoon, everybody. You're welcome to part 2 of this program. And like we know, the last is always reserved. Yes, the best, always reserved for the last. Thank you so much for coming out. I would say recognition as before, but I would specially recognize the state lead of NBA Women Forum in the person of Ofonime Iniobong Etumwa. Please, can we appreciate her? Thank you for coming around, ma. We also have with us Nurse David Rebecca. Nurse David Rebecca, you're welcome, ma. FIDA in the person of Ime Edebeka. You're welcome, ma. We also have the Vice Chairperson of FIDA in the person of Miranda Esquire. You're welcome, ma. And the Financial Secretary of that prestigious body is Ebi Ikenwe Esquire. Thank you very much, ma'am. And also the branch facilitator of the Women Forum in the person of Chinelo Oboke Esquire. You're welcome, ma'am. We recognize the vice branch facilitator in the person of Mabel Ahamisi. Mabel Ahamisi Esquire. You're welcome, ma'am. And the secretary is Elizabeth Thompson. You're welcome, ma'am. We also have the publicity secretary to be Oinye Udenkulo. Thank you so much for coming. Please, to kickstart this session, can we rise as we take the women and all around the world and are longing to be free. No longer in the shadows, forced to stay behind, but side by side in true equality. So sing a song for women everywhere. Let it ring around the world and never, never cease. So sing a song for
equality, development, and peace. So sing a song for women everywhere. Let it ring around the world and never cease. So sing a song for women everywhere. Equality, development, and peace.
Thank you very much. May you take your seats. All right, at this very juncture, may I invite the branch facilitator of NBA Women Forum, Eket branch, for the opening remark. Please, let's appreciate her as she come up. Come on. Thank you.
Distinguished learned seniors, learned colleagues, esteemed guests, ladies and gentlemen, good afternoon. Standing on established protocol, may I warmly welcome you on behalf of Nigerian Bar Association Women Forum to this special joint session with FIDA Nigeria Eket. The theme for this session, Beyond the Courtroom, Building Wealth, Wellness, and Worth as Lawyers. This theme reminds us that being a lawyer is more than the cases we argue or the briefs we prepare. It is about living fully, financially, and being independent, nurturing our mental and emotional well-being, and creating values that extend beyond ourselves. May I thank the chairman of NBA Eket branch, the person of Barrister Kisi Maban, for giving us this opportunity to participate in this session. This is the first of its kind. We've never had such an opportunity to anchor a session in the NBA week. We also thank the chairman of the Bar Week Planning Committee, and the person of Chief Emma Mbo, PhD. But I also thank the speakers that have agreed to come and share their wisdom with us in this session. My heartfelt thanks also goes to FIDA Nigeria Eket for this collaboration, and to every one of us that is here present for being part of this session. We appreciate you all, and we promise you that your stay will not be in vain. You will acquire knowledge that will help you move to the next level, and at the end, you will be grateful for being part of this session. You are all welcome. Relax and enjoy the session. Thank you.
Thank you very much, Ma, for that very short but powerful address. Thank you so much. Please, at this very point, we'll move into the session proper. I'd love to introduce the panelists, and the person to chair this very session is no other person than Tare Iwang Esquire. She is the principal attorney of Standard Attorneys. She also is the former NBAWA facilitator. I am informed that she was the pioneer facilitator of Eket branch. Thank you very much, ma'am. You're welcome. Nurse David Rebecca. Registered nurse, a registered midwife. She's also a registered nurse educator. She has a master's and PhD in view. But that's a very powerful one. Thank you so much. It's a privilege to have you here. We are very sure that after today's session, we will be healthy lawyers. Thank you so much for coming around. And there was no other person than our very own Mojisola Tijani Esquire, a very dedicated legal practitioner professional with strong commitment to justice, integrity and protection of human rights going around. You're welcome, ma'am. Please, at this very point, I would love to hand over to the chairman, speaker, in the person of Ofonime Inyobo Etukumwa. She is the state lead NBA Women Forum Akwa Ibom State. A very massive work. Thank you so much, ma'am. Assistant Director, Ministry of Justice Akwa Ibom State. Development Specialist, Women Economic Empowerment Advocate, and a legal innovator. Ofonime Etukumwa is a dynamic legal professional and public sector leader dedicated to driving transformative change through law, innovation, and economic empowerment. As an Assistant Director in the Akwa Ibom State Ministry of Justice, she has distinguished herself through exceptional service in the Department of Public Prosecution and the Department of Legal Drafting, where she has contributed to strengthening justice delivery and policy reform. Armed with an LLB, LLM, and an MBA in project management, as well as a specialized certifications in procurement, construction law, and business management. Ofonime brings a rare blend of legal expertise, strategic leadership, and development competency to every role she undertakes. She has a stint with international development institutions, notably serving as an ombudsman under the World Bank-funded Nigerian Erosion and Watershed Management Project, NEWMAP. She currently serves as the State Project Coordinator of the Nigeria for Women project in Akwa Ibom State, a major World Bank, federal and state government initiative focused on women's economic empowerment and financial inclusion. In addition, she is the focal person for the Human Capital Opportunity, Prosperity and Equity Project, that's the whole project, Akwa Ibom State. She is a member of the State Steering Committee of the UNDP Young African Innovates Program, where she leads interventions that promote poverty reduction, wealth creation, and human development. A passionate advocate for gender inclusion and professional advancement, Ofonime is the Akwa Ibom State lead of the Nigerian Bar Association Women Forum (NBAWF) and an active member of the International Federation of Women Lawyers (FIDA), where she has held executive roles. She champions mentorship, capacity building, and policy frameworks that support wealth creation and social equity. Driven by a commitment to service, innovation, and impact, Ofonime Etukumwa is a trailblazer shaping the future of legal leadership, human capital development, and economic empowerment. Thank you so much, ma'am. That's the person we have today as the lead person. Thank you very much, ma'am. You're welcome.
Thank you so much. The chairman of NBA Eket branch, the executive members, the chairman of the planning committee of the Bar Week, learned seniors, colleagues, ladies and gentlemen. You know, it is not out of place that anytime it is an opportunity for the women to make presentations, the hall is always empty. You will always see women. And I'm always thinking or taken aback to really ask whether it is actually true that women are only to stand behind the men, and then when it's time for the women to stand in front, they stand alone. So Eket's bar, leaving the women alone, shows that the NBAWF and the FIDA are only supported but with a very few men. So thank you to the men that are here. This is Eket Bar Week. It is not NBA Women Forum Week or FIDA Week. It is Eket Bar Week. And the topic carefully selected or chosen by the FIDA and the NBAWF. I think it is to the benefit of all lawyers and not only the female lawyers, so that when the female lawyers grow and span into financial independence, the men will not say, the women want to take over the bar, or the women want to take the lead. But I am very sure very soon the women will take the lead. Thank you so much. So thank you once again for giving us this opportunity to learn, to unlearn, and to relearn. So it is with great pleasure that I am here today, and I bring you greetings from the national, from the state arm of the NBAWF, and as well FIDA. You can't separate the two. Even if you separate the two, you won't be able to separate me from FIDA. So when we talk about financial inclusion, because I'm supposed to talk about wealth creation for legal practitioners, empowering lawyers for financial inclusion. When we talk about financial inclusion, let's paint a scenario. Time is already against us, and so we're just going to take the points and talk. I am very, very happy because from our flyer, we are not saying paper presentation, it is called a town hall meeting. And you know, when you have a town hall meeting, it is basically depth and in-depth discussion. It is not paper presentation. And so we're going to discuss wealth, how to create wealth, and how to sustain wealth. Imagine a period called legal vacation. What is the essence of legal vacation? To us, sometimes we misinterpret it to mean lawyers staying off court. It is a period for rest. And when you hear vacation, vacation means moving from your place to another place to rest. Abi? Please, let's communicate that it is town hall meeting. So, vacation is simply supposed to do what makes you happy, what calms your nerves, and then what builds up your mental health and sustain you. But how many of us as legal practitioners can afford a vacation? How many of us? And then I dare say, for next year's National Bar Conference, some of us have started planning this year. And so we say, okay, I want to go for Bar Conference next year. Let me give 5,000, let me give 2,000. Now, why can't we just wait? When Bar Conference comes, we'll just pack our bags and then we move. Yeah, because legal practitioner and legal profession, or the legal profession, so to say, or the practice of law has tied us down to we cannot make money. Oh, there is no money in law. Oh, there is no money in law. But there is money in law. I can still also recall when I don't need the cameras for this one now. Okay, we're supposed to contribute to host something, and then we're all lawyers. And we're like, okay, let's contribute 30,000 naira each. And you know, a lawyer called me after the meeting and said, often, bring down that thing to 10,000 or 20,000. School is going to resume. And so if we bring out 30,000 naira at this time, I don't know if you understand what I'm talking about. If we bring out 30,000 at this time, you know we are going to pay school fees. Please, we shouldn't as lawyers be bargaining school fees. Or thinking that if we take out some amount of money, we are inconveniencing ourselves. And then we can't do what we have to do. This is an opportunity for us to look beyond what we term the legal practice into the practice of law. And so I said here that we are gathered not only as advocates of justice, but as architects of value. And then the stark reality of our legal practice is on us, that we have so many brilliant legal professionals, then after years of practice, they find themselves financially insecure. Now, there is this paradox that rich in intellects but poor in financial outcomes, and I pray that is not the story of the legal practitioner. Now, with all apologies and intent not to demean our profession, it seems like the legal practitioner has been tied to the apron string of the Legal Practitioners Remuneration Order 2023. Oh, you can't make money out of this. I had to sit down to look at that order and read that order, and I am like, oh funny me, if you were in active practice, how would you feel? Yes, there is a window to charge higher, but then they tell you when you are 10 years post-call for this particular thing, don't charge below this amount. Have we all not seen the scale of charges? Now, if we have to follow that scale of charges strictly, then we will not have wealthy lawyers. We will not have wealthy lawyers. No. The Legal Practitioners Remuneration Order is not bad. It is a way of telling lawyers you need to make money. But imagine also a window of allowing us to leave our practice, not for the time invested in, but for the value we have given. So we now charge fees for our value and not for the time. Doctors charge for value. Architects charge for value. Surveyors charge for values. They will tell you, yes, we want to give you a land that is good. But a lawyer will not say, I want to defend you in a case that is good. They tell you for my time. So we should stop charging for time and charge for values. I remember when I had to diversify from legal practice, from going to court. I used to have calls, and let me confess, then I started my PhD in law, and I did the coursework. At a point, I had to travel, and so there was this social development work before me, and then I had my PhD here. And I looked at it, I said, PhD, I'm paying for it. This one is paying me, and it's from what I am doing here that I used to pay for the PhD. And I left the PhD and I started having calls. You are a lawyer. You should not be going into the community to do what you're doing. Lawyers must have prestige. You are a lawyer, and I heard this, you are a lawyer, you are a lawyer, you are a lawyer, you are a lawyer. And I now told the last person that spoke to me about this work, I said, lawyers pay bills. Lawyers pay bills. That there is nothing we are to do in the community, or there is nothing, no practice, no profession in Nigeria that does not depend on law. There is none. That's where you see medical law. Architects, they have their laws and values. And so what I am doing is an aspect of law that all lawyers must not go to court and wear wig and gown. But as long as you read law, it is an avenue for you to also make wealth and create wealth. And so I am very proud to say that I love social development work. So I wrote here that the practice of law or legal practice, as we should say, should be seen as business. It should be seen as business. There will be no wealth creation for lawyers if we do not accept our profession as a business venture. There will be no wealth creation. And now for every business venture, there is always capital and then profit making. Capital in this instance, as a lawyer, it's your LLB, it's your BL, it's you going to school, it's your NYSC. The profit should be what should come out of it. And until we realize that our profession should be treated as business, we will not make money from it. Medical doctors have realized that. That's why a doctor will open a hospital and then you pay for their card and then you do everything before they treat you. The agents have seen estate surveying as estate workers' business. And so we are now the third party coming to tell agents, I beg, is there land? If there is land, I write agreement to. If there is land, I write agreement to. Because we are not seeing our profession as business. We are seeing it as the work that we are doing. No. And between capital and profit, there is a margin, there is a thin line. And so, for you to have your capital, we've gone to school. And for you to get the profits, there's something we have to do. And that takes us to telling us that there are diverse aspects of legal practice. We have entertainment law, which you have to be in that field. You have to mingle with them for you to get from entertainment law. We have sports law, we have aviation law, we have construction law, we have medical law, name them. And that is that line between your capital and what will give you your profit. That's where your financial independence lies, your specification in law. Now, in what I do, I stand out. And most times, my colleague from other states will ask me, said, SPC, please, what do we do? Use your knowledge of law as a lawyer to tell us what to do. And so where I am, I still do the practice of law. Until we treat the practice of law as business, the dividend are still far. Now, we hide under there are too many lawyers called to bar. I don't know if people have been hearing it also. Lawyers say, why lawyers don't make money is because they call plenty people to bar every year. Please, they also call plenty medical doctors to the profession every year. There are plenty pharmacists every year. The only reason that we are where we are is not because there are plenty lawyers that are called to bar every year. It is because there are too many lawyers downplaying the business-making aspects of the legal profession. Our values have been reduced and equated with street hawking. And so, we say, plenty lawyers. No, there are not plenty lawyers. We are the ones that have downplayed our values. We are the ones that have downplayed what we can offer. And so, we are now called charge and bail lawyers. Like, what is charge and bail? Okay, go to prison if you don't have a lawyer to defend you. Does that make me charge and bail? But then we accept that we are charge and bail lawyers. And they tell you charge and bail lawyers and you laugh. And then you say, please go. No. There's no lawyer that is charge and bail. Because the law says, for you to be granted bail, there must be a representation. And it is a lawyer that can represent you in court. And that is the value I give you, because I make you come out of prison, I make you come out of jail, I take you on bail, and I defend your matter. And so why do we reduce ourselves to charge and bail lawyers? And after that, the next thing is lawyers for franking of documents. You go to business centers, you see our agreements lying there. And then somebody will call you and tell you, please just give me stamp. Just give me stamp. Have people not been hearing it? Oh, it doesn't happen in Eket. Just give me stamp, we'll find you something. This agreement is everywhere now. Please, if you go to Google, you'll see prescriptions for different ailments. Do they go to Google and call the doctor, please just sign this thing, just sign it, let me go to the pharmacy to buy something? No. But because we have given out ourselves for a plate of porridge, and then we keep staying where we are. Now, okay, let me rush on. What are we to do? One, we need a paradigm shift. From being service providers to being wealth creators. We are too much of service providers. If you ask so many lawyers here, what made you read law? You will hear, because lawyers used to look like they have plenty money. That's what I used to see. And there was this prestige that comes with it. But now, I pray that the labor of our heroes past shall never be in vain. So to create wealth, first we must have that reorientation of our minds. We must have that paradigm shift, that we are not charging fees for time, but we are charging fees for the impact we have created in your life. Two, let's just briefly look at the LPA and the ethics of wealth creation. Rule 7 of the rules of professional conduct says that a lawyer shall not, while practicing, engage in any trade or business which is incompatible with the practice of law. And then it goes to say, a lawyer shall not, while practicing, engage in the business of buying and selling commodities, or engage in any trade or business which is incompatible with the practice of law. And let me go to that buying and selling of commodities. As a lawyer, and then I take the records of proceedings and I publish the judgment on a law report and I send it to you. You buy it. Please, what is that? Is it not buying and selling? Oh, that particular buying and selling is consistent or compatible with the practice of law. And so I say that I think it is time we stop shooting ourselves on the foot to remain poor, while other professionals have changed their mindset to create wealth. We are not saying that a lawyer should bring tomatoes and garri to the courtroom to sell. No. We are not saying that a lawyer should, in a part or in a room of his or her chambers, she should have a store where she sells food items or where she does restaurants. No. No. And what I'm saying is that the writers of that law should interpret it to let us know what they meant by the business of buying and selling of commodities. Because this has made several lawyers poor. So to me, I felt that the interpretation of that law means that you should do businesses that bring dignity to the legal profession. So if you open a shop in the market, it is still a business compatible with the practice of law. Yes? If you have a shop at the market, you are not in any way bringing disrepute to the practice of law. After all, you don't wear your wig and gown there. And also that whatever business we do should not conflict with our duties as a lawyer to the court or to our clients. I also think that that business should be transparently managed and does not compromise ethical obligations. So I wrote examples of businesses I think is permissible because after all I do agriculture. And so I said real estate investment or property ownership is business. You buy property and you sell property is business. It's buying and selling. But it doesn't conflict with the practice of law. We write, publishing, lecturing, passive shareholding in companies and corporations, consultancies, serving on boards as advisors are not practices incompatible with that of a legal practitioner. And so these are areas we should look at to create wealth and financial independence. Let me rush on. Understanding wealth and income. I said that income is what you earn from your work, while wealth is their continuous earning, even when you are absent from that work. And so sometimes, or most times, we realize that lawyers have income and not have wealth. I don't know if I'm lying. Maybe in Eket we have wealthy lawyers. But I know some other clients, we have more of income earners. Imagine register for FIDA. And I was hearing steadily, please, I would have loved to come, but I cannot register. And I said, no, far from it. That as female lawyers, we are going to try to create wealth and make wealth. And that brings us to multiple streams of income. Beyond litigation and retainership. There are a whole lot of things to do. There are emerging legal frontiers we can create wealth. Technology and digital law. Have we embraced technology and digital law? I told some of our MBAWM members in New York that please try and register for AI training. There are some that are free. There are some that are just for a fee if you are doing advanced training. Before you know what is happening, we will leave paperwork. In years to come, everything may be automated. And so if you are not in tune with the future, you will not create wealth. So we have data protection, fintech, blockchain, and AI regulations. We have ADR, we have intellectual property monetization. If you go to the eastern part of Nigeria, they know how to use intellectual property monetization. There is energy transmission and climate finance. We have equity and private equity and venture capital advisory. Thank God I came to meet the other speaker talking about it. We have estate planning and wealth management. And so, I said a modern legal professional should go beyond the boundaries of traditional practice models. Wealth creation is intentionally built through diversification. And I can tell you that I can beat my chest to that. And all apologies to the system. I think majority of what I have earned is from diversification and not from legal practice. Yes. To be financially independent also, we need financial intelligence. We make money, we spend money. Wealth not properly planned or income not properly planned cannot amount to wealth. So wealth is income properly planned. And so, what stops us from forming into a micro cooperative where 5 minutes more, okay, I'm really sorry. We form ourselves into micro cooperatives where we save our income and also give out our income as loans to us, and we make wealth from it. That is financial literacy. So as we invest, as our cash flow comes in, we should be able to set aside a part of our income for cooperative development. That's our own self-development. Practice it. I know when we tried doing it at Yoba, I don't know whether it's still working. A lot of people said, where will you get money to serve? No. Try to serve every one kobo that you have. From every money you make, whether it is from appearance in court, whether it is from your franking of documents, or anyhow, let's cultivate that habit of financial literacy to serve some. From experience, I work with over 72,000 women which we form into cooperatives. And they started with 100 naira, some women started with 100 naira per week. That is the rural women. And to my greatest surprise, that was 2022 when we started our group savings and loans within the cooperative. The group that had 100,000 naira weekly savings, they now save 500 naira. That's their minimum savings per week. Their maximum savings is 2,500 naira per week. And when they cash out, because the way we form them and train them, they're not supposed to touch that money until the end of the year. That's 52 weeks. And at the 52nd week, our first cash out in 2022 was about 100 and something thousand naira. We followed up with the group 2023, they had up to 300,000 naira. And that same group that started in 2022 with 100,000 naira as their cash out, as at this year, they've cashed out 3 million naira. And it is wealth built big time. So wealth does not just come. Financial independence does not just come. You have to consciously create it and consciously work towards having it and earning it. It's something you keep. Wealth is something that speaks for you, and then you go for your legal vacation, and then your wealth is talking for you, and not thinking of, if I leave, how will I make money? And so to end it, the ultimate goal for financial independence is its integrity. If you do not have integrity, you will not build wealth. If you are forced to create wealth, you will not make wealth. If you are coerced into making wealth, you will not create wealth. But if you personally sit back and think through it and draw your cash flows and try to take down every income and expenditure you make, you will create wealth. Emotional intelligence and mental health. As lawyers, we must understand that health is wealth. And engaging in activities that build our system mentally, emotionally, and physically makes us wealthy. Imagine sitting down and reading only to have income. You don't have a reservoir. When you fall ill, you take that income to cure the sickness. But if you create your wealth and then you consciously create a reservoir, even the federal government have reserve funds that has the authority and power to print and mint at any time they so wish, has reserve funds. And so that's wealth creation. Whether it is mismanaged or not is none of our business for now. But our own is that we should try to have reserve funds to create wealth and not mismanage it. And so in concluding, my fellow legal practitioners, now is the moment to write a new legacy. Let us rise from the consciousness of scarcity into the possibility of abundance. Let us transmit from billable hours of wealth to billable out of wealth ownership. Let us empower ourselves so that the law remains not only a noble profession, but also a gateway to financial sovereignty. The future belongs to lawyers who do not just interpret wealth, but create it. Let us be those lawyers. Let us build. Let us own. Let us lead the way to wealth creation. And as we do it, I am very sure the legal practitioners and even the legal profession will be so proud of us. Thank you.
Standing ovation. Thank you very much, ma'am. We need to be intentional about creating wealth, and we have to charge for value. Please.
Thank you, the speaker, and with your well-enriched CV, you have given us a very good presentation that has made us to know how we can manage our wealth and also to enrich ourselves more. Like one thing she just said, she said we should stop shooting ourselves on the leg. And we know what it takes to do that. It's something that has always been in our platform, so we know what it is, you know. And particularly, she said, we should stop charging for time, charge for values. It is really, really rich for us to know that we know how it is. Sometimes our clients will tell us, is it not a power of attorney? It's in your system, just do it. And some of us, we also, while we are charging, we have that in our mindset. It's not, it won't take me much time, let me just do it. Whatever it is, something is coming out from it. But today, we should start charging for values. Thank you. And then, thank you so much. Thank you, State Lead. Thank you. And we'll be asking the second discussant, the Nurse David Rebecca, to take the stage. But please, Madam, 15 minutes, please. Let's know how we can manage our mental health. Thank you.
Good afternoon, everybody. I'm very delighted to be amongst the most learned people in the whole world. It's indeed a great privilege to talk with us. I just want to say something that what we are going to be talking about is what we know already. It is not going to be strange, but an aspect of it is where we want to lay emphasis on, and that is knowing, and actually doing. Okay, for today we want to look at mental health and emotional resilience, recognizing burnout and stress signals, self-care, and healthy routines. Now, what is mental health? The last discussant went in there a little, but we just want to look at mental health. It's with us, it's our thing. Mental health, I just want to paraphrase. I want to define mental health as a state of psychological, emotional, and social well-being. Those are the three components that constitute mental health. Psychological, emotional, and social well-being. Well-being is the key word there. Now, how well is our psychic? How well? And when we talk about psychology or psychological, what does it even mean? It's a state of our mind. I hope we know that even the scriptures say that we should guide that our mind jealously, because it's from there comes the issues of life. So we really have to be mindful, intentional. I just want to remember what I saw sometimes in 2020 during the pandemic. I noticed someone was wearing the nose mask on the head. And I was wondering, you know, we play and we joke about a lot of things, but sometimes in the midst of those jokes are realities. And the person was saying he is protecting his mental health. So today I want to tell us that mental health is a big deal. It is not something we have to joke with. Now I just want to look at a small scenario. I just want us to look at this. Barrister David sat in his office long after everyone had gone home. His suit jacket was on the chair. His tie loosened. Now this point, I'm even happy that he recognized that something was wrong and removed his jacket and then loosened the tie. And his eyes were fixed on the same case file he's been looking at the past 2 hours. Now what does this mean? That sometimes we look and we are not actually seeing. It happens not just in the legal profession. It happens, and it therefore means something is going on in the mind. It's either the mind is fact out, that the body is requesting for rest, and sometimes we say, when I'm done with this, when I'm done, you know now that of recent time people are requesting for more hours to add to 24 hours, that it is not enough. That is the reason we have to be intentional. Please, I'm just going to summarize because the way I am given 15 minutes, God will help us. So we really have to be intentional. We will never be able to finish everything. So we have to prioritize. So now what is he doing? Staring at the same case file for 2 hours. He hasn't eaten all day, very bad. Because it is part of it. He said his phone buzzed with missed calls from his wife, children, even his doctor. Someone said, when you start missing your lawyer's call, something big is wrong. And he's ignoring the calls of the family and even his doctor. It therefore means something is wrong. Now we are saying here that the case is important. That case file, that case that he's looking at, he's staring at for 2 years or 2 hours is important. But more importantly is his health. Are we together? Very, very important. Yet he could not stop. He His chest felt tight, his head ached, and his patient had one thing. A few weeks later, the same barrister that used to be very confident, respected, and once full of life was down, helpless, and diagnosed with severe burnout and hypertension. Now, let me ask us, how many of us as lawyers have been in this case, in this kind of situation? The more reason we are here, where your body is present and your mind felt completely drained. So we are going to look at, we keep pushing ourselves. So let us just rush to what should be done. Don't forget, we are looking at emotional resilience. And now, what is emotional resilience? We've talked about mental health as being that state of psychological, emotional, and social well-being. Some of us have disconnected with friends. We've disconnected with everything except our work. Truth is, we cannot give what we do not have. Now, it gets to a point that we are completely drained. We are empty in the inside, but we do not know. What is emotional resilience? By emotional resilience, we mean the ability to adapt. It is not true that we will lead a stressless life. No. To say the truth, stress is a ginger, it's something we need to keep us moving, to push, to achieve. But the issue is where we do not recognize where we have to match breaks, where we do not recognize the stress symptoms and signs, signals, such that we can say, I am not okay today. There is nothing wrong in saying, let's see tomorrow, so that you listen to yourself, take care of yourself, because you need your life to win those cases, true or false. Yes, we need our lives. So when we push so hard, chances are that sometimes we may not even have that life to push forward. So now, what do we understand as burnout? According to the World Health Organization, burnout is a state of chronic physical and emotional exhaustion caused by prolonged stress. And for lawyers, it is often hid behind, I am busy. Lawyers are always busy. They have deadline to catch up with. There are some clients that stress you out. There are some cases that even take a toll on you. But what is more important is to pay attention. And you know the problem. If you do not even know what to watch out for, then it's a big problem. Common warning signs that tells you you are burnt out. Constant fatigue, even after resting. I don't know any of us that has woken up after sleep and is still feeling very tired. It happens. Irritability and cynicism. Now, when we talk about irritability, you snap at everything. You're angry. Everybody is irritating you. Something is wrong in the inside. Reduced focus. That thing we say, the more you look, the less. You keep staring, but you're completely blank. Emotional numbness. I can say leprosy. You know, you're numb, you're completely off. You cannot feel, no feelings. Don't forget, emotion has to do with feelings. You cannot feel anything again because you're out. Then the physical signs include headaches, body pain, sleeplessness, which we call insomnia. Now, a young lady once told me, I don't cry anymore. I just stay. That is not toughness. It is emotional burnout. So what can we do? And this is the most important part. We all get to this point, and this point will always be around us. But what can we do? First is acknowledge your limit. Are we together? Acknowledge your limit. Truth is, I am not you. You are not me. And our limits cannot be the same. So acknowledge your own limit. Know where you can match break. Remember that you are only a lawyer. You are not a machine. There is an extent you can push. Delegate when possible. You must not do everything. Delegate duties. Let someone assist you. Take breaks intentionally. Why the word intentionally is important is because if you want to just do it anyhow, you will not rest. Just give your time. When it is this time, I must rest. Seek professional help. When you know something is wrong, please talk to somebody. Don't try to prove stuff. Remember, you cannot pour out of an empty cup. And another thing is that if you check, like maintaining a car, it is not until we wait and the engine fails that you start working. You must have checked one or two things to put it in order before it goes bad. So these are the things we have to do. Now, going to the self-care and healthy routines. Let us now move from awareness. We know, and this is what we've always known, but because we know this much, what have we really been able to do? What have we been doing to help ourselves? Self-care is not luxury. Like the last speaker said something, you must not have it all to take a vacation. Self-love, you should love yourself to that extent that you want to take out time and rest outside your home. It is a maintenance. So when we say self-care is not a luxury, you feel until you have so much, you cannot lodge yourself in a hotel and then tell someone, ring a bell, let them bring you food. Let them bring you food and take the plates. You are not washing the plates at that time. It is a maintenance. So maintain yourself. Practical self-care routines for lawyers. Please, the physical aspect, you have to prioritize your sleep. Please, did you hear? Yes. Prioritize your sleep. And we are saying here that 6 to 8 hours should not be negotiable. I know you are beginning to say, as in how? 6 to 8 hours of sleep, not negotiable. Try and eat a balanced diet. Reduce your caffeine intake and processed food. It is possible. You can do this. Move your body. So that even if breaks, that's why we have to be intentional. You just know you've sat for too long. There's something you can do. You're not going for anything. You're just walking briskly because you know the advantage of what you're doing. Please, check up yourself. Medical checkup. Regular blood pressure checks can help. Then when we talk about emotional care, please learn to pause. Learn to pause. Learn to pause. Learn to pause at some point. Engage in non-legal activities. Non-legal, everything must not be with your colleagues. Sometimes step out
and know what is happening elsewhere. Engage in some music, painting, volunteer work, family time out. Some of those things can keep us mentally healthy. Then mental health, you start your day with mindfulness, prayer. Set realistic goals. Sometimes the goals we set are unrealistic and it therefore mount pressures on us. Disconnect from work after hours. Just intentional. Take off. Don't take some work home. Just let them be in the office. Not every call deserves
an indulgence. I will end by saying this. The strongest lawyers are not those who never break, but those who knows when to rest, seek help, rise again with clarity. So today I challenge you to take one simple action. Go for a walk, talk to someone, reconnect with your peace. When I say your peace, you know what makes you peaceful. Reconnect if you disconnected. Check with your doctor. Because at the end, your mind is your greatest courtroom. If you win there, you can win anywhere. And I take that again, because at the end of the day, your mind is your greatest courtroom. If you win in your mind, you can win anywhere. Thank you very much.
How well is your well-being when it has to do with our clients? We always take our clients, let me call it problems, personal. We want to meet up with the target. So how well is our well-being? When some of us will be asking for more hours to be added to 24 hours. So as we are going back today, let's know that it is okay to say I am not okay. May I please welcome our next discussant, Mrs. Moji Sola Tijani, our past of the vulnerable.
Thank you, man. Thank you very much, moderator of this session. Thank you very much for the MC who wanted me to sit down. But having heard our beautiful nurse say that you must not stay in one position, you must move. Thank you very much. If you had done that, it would have affected my mental health. Because, first of all, I would wonder why everyone has stood up to talk, and when it's my turn, I have to be seated. But I understand from a place of love, and I appreciate that. Thank you. So I have to talk like the town hall meeting that my state chair have said, we're in a town hall meeting interactive session. And I'm to talk about lawyers as agents of change, advancing the rights of the vulnerable. Having listened to the two speakers, I am grateful to the leadership of the MBA Women Forum and FIDA in collaboration for taking time to bring about this topic. So from the totality of it, we're looking beyond the courtroom where we were called to serve. We're looking at creating wealth, we have looked at wellness. And we're also thinking of what's our worth other than being in the courtroom. And I will say that the legal profession is considered noble. That's why we say we're always very proud. I remember when I wanted to read law, I heard it's a noble profession. And the state leader said, you carry yourself with dignity. Sometimes as a lawyer, you don't even have anything in your pocket. But the way you carry yourself when they call you, it shows that it's a noble profession. But beyond that, it calls for commitment to justice, strong ethical code, and a dedication to serving others. Your worth is not only in the courtroom. The profession, though our profession is one we have to use as source of income, like the first speaker has said, there are two things to getting money, income and wealth. Most of us are living on income. as professionals. But you say our first call is founded on what? Justice, equity, and service to humanity. We are called lawyers because we are the catalyst. I know the men will understand what the catalyst means in the car. We are a catalyst to ensure that justice is not only served, but has been seen to be served. And we're saying lawyers as agents of social change. Who is someone who can say, oh, this person is a social changer? Is an individual or a group of people in the society who works to influence or transform the society. In a nutshell, an agent of social change is someone who brings about positive transformation in the society. As lawyers, beyond the courtroom, how have we affected our society? In organizations that you belong, in groups that you belong, do they know your value as a lawyer being there? Some of us belong to other groups that fight for, human rights and all that, but what is your value as a lawyer beyond the courtroom, beyond wearing the wig and gown and arguing your cases and representing your clients? As lawyers and agents of change, we must not only be seen, but must be heard and seen to be using the law as a tool. That's why we went to school. Some of us have the laws, important laws at the tip of our fingers, and we can talk at it and go to quote section this and section that. Beyond that, what do you use this tool to do? How does it affect the next person close to you? How does it affect the vulnerable? How does it affect those who do not have the wherewithal to even get or engage a lawyer to handle their cases? And this is where I want to talk about FIDA. FIDA, pro bono cases. And most of us actually do pro bono who are not FIDAs or FIDA members. We're going to start the session. I saw a lawyer and he said, FIDA matter, what are we going to start? Women matter. I told him, we actually love the he for she. Who stand with the women? See how empty the hall is. Please, I want to give accolades to all the men who are still in this hall. Please give them a round of applause. You were not influenced. You just knew that you had to be there to support the women. Thank you very much. Our call to justice does not just end in the courtroom, representing our clients or as gladiators of the courtroom. It goes beyond that, as we are called to help shape and influence norms, government policies, and to enlighten the society of their rights. I was speaking to the team lead just now. I said, lawyers, we spend time, we work, we struggle, and my lovely nurse said, take time to rest. Take time to rest when you have bills to pay. Sometimes they stare in your face. And we said, what are the things we can benefit ourselves? And I'm grateful to the membership or to the leadership of the MBA in their wisdom who have set up the MBA Women Forum. It's a forum that gathers women and talk about our welfare. Now, with her here, I just discussed with her, there are other things we can benefit, and she's going to help us with that after my discussion with her. But what am I trying to say? We look after ourselves, we also need to look after the next person. What does FIDA do? They promote, protect, preserve the rights of women and children through a legal framework, because we have the tools. And we know how to whip it. The law is an ass. Do you ever sit down to think why they say the law is an ass? Because you can flog it to suit any situation. And that's why everybody must be represented. And even in the criminal matter, you're still innocent until prosecution has proved it beyond reasonable doubt. So, let's be that agent of change. Ways in which you can be an agent of change as a lawyer. Identify injuries in the society. There is a campaign going on now. Who has heard about the Ochaya case? Have we spoken about it? Have we put it on any of our social medias? That's injury to one person, she's dead, but these people are still walking around and they were never sentenced. they were discharged and acquitted, even when the prosecution had enough evidence to nail it. We must never keep quiet, we must identify injuries, take action to correct them, not just see the injury and keep quiet. Work to influence people, policies, and systems to make life better for the society. Form groups of advocacy, like the FIDA, other human rights organizations, and work to ensure that we use this tool of law that we have to help the less people. Challenge systems. It's about time we challenge systems. This year's theme, we are tired of rhetorics. We need action. After this bar week, we're going to come up with a communique. That's the best that's going to happen. What do we do thereafter? What do we do thereafter? A lot has been said here. Most of us have listened to all the speakers. After this bar week, the communique comes out. After the communique, we'll go to sleep for another 1 year and we'll set up another team of people who are going to organize the bar week, and they'll come up with lofty topics that will shake foundations. And after that, what happens? We must challenge systems, advocate for reforms in legal and social systems, educate citizens through enlightenment programs and rights of their rights and duties. You're walking beyond the courtroom. Your job as a lawyer doesn't end in the courtroom. Move out, showcase yourself, let people know that a lawyer is within a group or in the vicinity. Defend the rights of the poor, oppressed and the marginalized. The topic is advancing the rights of the vulnerable. Some of us feel that we cannot represent because we are not being paid. But I tell you for real, if you do pro bono cases, the thank you get, you can't quantify it. Because if you are able to defend the person and the person can get his or her right back, that person will never forget you. And I tell you for free that the person will be your mouth, someone to advertise. Even though we say lawyers, you're not out to advertise, but those people that you have helped will advertise for you. Are you getting what I'm saying, my beloved colleagues? So, promote justice and equality and equity. Remove the fact that this is a female, this is a male. People are vulnerable irrespective of gender. As our worker will come and be bugaing outside, we have seen cases where the woman beats the man. We don't support those women. It's not everything you bring to FIDA that we carry on our head. We make sure that we ensure that most men are going through a lot too. So being vulnerable is not gender-based. Please. What are the obstacles? You will face obstacles. You will face challenges while you're doing this advocacy. One, what are the things we face? I speak for FIDA because I've been a FIDA member. Most of the female here are FIDA members. The one we suffer the most is lack of financial aid. Limited access to legal aid funding. Just recently, the FIDA chair, there was a case of rape. We have everything, but we don't have the resources to push for these matters to be moved. What happens? In the end, the suspect family will meet the family of the survivor and look for us, they will give them money. I mean, poverty speaks so, it's glaring, and they say, look, we are tired of coming to the police station. These people have offered to give us something. What happens? That person will go away, and they're still walking around and going to get more victims. So the one problem we face, advocating for the vulnerable to ensure that they have their rights, is funding. Corrupt criminal justice system. I don't want to talk too much about that. You know what happens. Sometimes you don't get justice, even when it's glaring that you have killed them. At least there are 2 or 3 instances that happened this year. Do we still remember? In Anambra, you did not hear. A lot of our brothers have died, maybe because they are speaking the truth or they are standing for the vulnerable. In conclusion, my dear beloved brothers, as gentlemen of this noble profession, we are the watchdog of the society. We keep the checks and balance, and we must rise to our duties, beyond the courtroom. This is a call to action. Let our duties move beyond the courtroom. Let's truly be the voice of the voiceless. Let's contribute our quota to ensure a safe and equitable society. Thank you.
As we go home, we should be able to practice it and hold on to it. But meanwhile, our lead speaker has something to tell us concerning advertisements. Please.
Thank you so much. I'll be very brief. I want to thank Auntie G for inspiring us for social justice. And she said something about lawyers and advertisements. Yes, the legal practitioners and says lawyers should not engage in advertisements. And still acts incompatible with the practice of law. But in wealth creation, you know, advertisement is a process of wealth creation. Yes. Advertisement is a process and it's very key to wealth creation. If you don't blow your trumpet, who will? And so, they said do not advertise as a legal practitioner, let your work speak for you. And then, with the advent of social media, I have a blog on social media which I report cases, which I speak about the law, and I talk, I just come out to tell you various aspects of the law. And I am in my office, I know the law, there's something that this person has publicized knows. Please, who will they go for? The one that has made themselves known. And so please, our phones have wealth creation in it. Everything we want to need to make wealth is on our phones. Hit your social media pages. Please talk on Facebook. Do not say, I am a lawyer, I can do your case. Please talk law. People love to hear law. Talk law. Improve your LinkedIn profile. Let people see you, be visible. Please, LPA, let's change this. Lawyers should not advertise. Lawyers are hungry. Lawyers have bills to pay. And if we are not known, how will we create wealth? Thank you.
Thank you. We have come to the end of this section. I want to appreciate all of us for taking time to be here with us. And our male colleague, I can see all of you, but time will not permit me to mention your names. We know you are well represented here and you are for us. And at this point, I'll welcome the chairperson. I'll welcome the chairperson of FIDA to give us a closing remark.
Please, because of our speaker that needs to be out of here as of 10 minutes ago, please, let's take the picture and then I'll give the closing remark after that. Please. I have so much to take home from this session. So, I want to appreciate the speakers, the lead speaker and the discussants. I want to appreciate every one of us that sat in for this session. We so appreciate you. We thank the NBA, Eket's leadership for this great opportunity. And as we go, I know this is the last plenary. Let's take with us what we have learned, and I know we will do better in our practice. Thank you very much, everyone. God bless you.